The hearing today is in the matter of CFI 065-2020 before Justice Sir Jeremy Cooke and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on the judge's instructions. The claimants are represented by Al-Tamimi and Company. Lead counsel is Tom Montague Smith, QC, assisted by Matthew Watson. The defendants are represented by Taylor Wessing, LLP. Lead counsel is Orlando Fraser, QC, assisted by Edward Crossley and Hussein Sharafi.
Very good. All right, have you discussed between you timing and how you'd like to divide the time, and indeed when we're going to take breaks and the like during the course of each day?
Yes, my lord, we've discussed timing. We're in your hands on breaks. In terms of timing, I'm going to try to take 4 hours. If I can do it faster, I will. My learned friend will then have 4.5 hours, and that will leave me with half an hour for reply. And I think that's uncontroversial. In terms of breaks, we're obviously working on 2 different time bands, so we're very much in your hands. There's room in the timetable for an hour's break. Whether we do that by way of 15 minutes and then 45, or by way of just an hour for lunch, it's entirely up to you, my lord.
Well, I think it's a question of simply whatever's convenient, really.
I agree.
I should say that I have cleared my diary for tomorrow, so that I have in fact a full day tomorrow if need be.
That's very helpful. Thank you.
I can also tell you that I've read the skeletons, and I hope I've read everything that is directly relevant in terms of the witness evidence, and also at least the essential documents, as I understand it, from bundle 9, which have been referred to by the witnesses and indeed in the skeletons.
Yes, my lord.
So I'm reasonably familiar with the whole picture.
Thank you. There was also a further witness statement from the defendants last night.
Yes.
I don't know whether that made its way to you.
Yes, I've seen that and the documents, and I'm inclined to allow it in unless you have some rooted objection, Mr. Montague Smith.
No, no objection. And in fact, my 4 hours is going to include time just to take you through some of those key documents. So hopefully there'll be plenty of time in the timetable to get through this.
Okay.
So, my lord, those present have been introduced, so I'll skip that bit if I may, and just get into the application with your permission. So
yes.
Your lordship's seen this is an application for immediate judgment on the whole of the claim and the counterclaim in favour of all of the claimants on the whole sum claimed and for the claim for specific performance. There's that discrete claim for specific performance of certain security arrangements. In the alternative, the claimants seek immediate judgment on those parts of the claim and the issues which your lordship is satisfied have no real prospect of success. What I was going to do is give you a very broad outline. You may have this already, and then go to the background, take you through those documents in the run-up to that meeting on the 16th of December, which your lordship will have seen is critical to parts of the defence that are being advanced. So just to start with the very broad outline, the sort of helicopter view, you'll have seen this is a facility, a restructuring facility, which was advanced partly as conventional lending and partly as Islamic lending. And the total exposure was about 1.75 billion dirhams. Now, with interest, murabha profits, late payment fees and the like, by the 6th of January this year, that was up to nearly 2 billion dirhams. There's a calculation in the bundle for that, and there's been no response to that. That calculation will need to be updated, and we're very much in your lordship's hands as to precisely how that happens. If you agree with me on the issues, there'll be an issue as to then the quantification, precise quantification of all the interest, profit and all the rest subsequently. We had proposed to provide you with a very short witness statement, just giving that updated calculation. It's a rather complicated calculation, but we can deal with that, I hope, in due course. And if we can produce it during the course of the hearing, we will.
Well, I would have thought that if we get to that point, the sensible thing for me to do is to give you a reasoned judgment and then fix a date, so to speak, for which any judgment would be operative and the calculation can be done. So if we get that far, that's the way to go, isn't it?
Thank you.
Just to stop you before you go any further, though, in relation to the second possibility of immediate judgment on some parts of the claim, my immediate reaction to that is, what's the purpose of that, unless it really results in a money sum?
Well, the purpose of it would be to avoid great swathes of trial. So, for example, one of the critical issues is, one of the issues that's raised in the defence is it's said that Murabha lending is void as a result of various aspects of Sharia law. And it's said, oh, by the way, you need expert evidence of Sharia law in order to even look at that. So if your lordship's with me on the fact that my position, which is that it doesn't even arise, you don't even get into Sharia law, then we can avoid days and days of trial and the expense of all of that. And if, for example, you may find, for example, it's possible. So there's a factual issue, which we say we can show there's no real prospect on the facts of things that are alleged to have been said at this meeting. And in particular, this claim that there was a guarantee, a commitment given that no bank would provide working capital. And my position is, even if you were to accept that as being a real prospect of having a real prospect of success, all that would get my learned friend to would be a counterclaim by the defendants against Noor Bank, which could not be set off against any lending. And so ultimately, what is now a debt claim for 1.75 or 2 billion dirhams would become a claim by the defendants against Noor Bank, which wouldn't interfere with the enforcement of the facility, and would be a standalone counterclaim, and subject to the usual rules, such as, for example, security of costs. So there would be a real purpose for some of that.
Yeah.
It depends, I think, on which of the issues, if any, you're with me on, and we'll see how that shakes out. Now, as I said, these were sums that were advanced to restructure various debts within the whole of the group, the BBIH group, which is all of the defendants, save for D2, who is the ultimate beneficial owner of the rest of them. The holding group is the final claimant, D9. Now, final defendant, sorry. The debt was therefore amongst the group, but was consolidated into the first defendant, and then the other defendants gave various forms of guarantee. So the second defendant, known as the chairman, or Mr. Al-Maheri, he is the chairman of the group as a whole. He gave both a personal guarantee and a guarantee as a UAE law establishment. You don't need to worry, my lord, about the personal guarantee. That's not part of this application. Everybody agrees that the debts, if there are any, have not been serviced and that the bank has given notice of default. But what the defendants do is they raise essentially three types of response to the claim. Two of them based on things said at that meeting. So the first is they say that as a result of things that are said at that meeting, and in particular, the commitments, the threat that was made by Noor Bank not to participate in the syndicate, they say that gives the defendants the right to set aside the whole of the financing and counterclaim in damages. So they say one of the banks, the eighth claimant, Noor Bank, threatened on the 16th of December not to participate in the financing of the syndicate, and demanded additional security as a condition of doing so. And that security was later provided as a side agreement between, on the one hand, Noor, and on the other hand, the group. So that's the first ground, it's duress, that threat. The second ground is that they say at the same meeting, someone within Noor Bank, they don't say who, made a statement to the effect that they guaranteed that Noor Bank would provide working capital facilities of at least 100 million dirhams over and above the debt restructuring that was being offered. That, they say, created a collateral contract, or alternatively an implied representation that Noor Bank had reasonable grounds to say that working capital would be provided.
I don't at present understand the latter point at all, but no doubt Mr. Fraser can develop that. It seems to me it's a promise as put, which means it's contractually enforceable or it isn't. I can't quite see how the representation of state of mind or future intention arises, but no doubt you'll illuminate me, Mr. Fraser, in due course.
We say it doesn't make a difference because if, as we say, that sort of promise, so imagine a promise of that sort had been made, it has no contractual content. It can't work. It's a promise to provide working capital on what terms, with what security.
I understand that point. It's a question of characterization. I don't quite see how it amounts to a representation of any kind. As a matter of law, it's a promise which is either contractually enforceable or not. But anyway,
you'll hear from my learned friend on that.
Yeah.
So both of these, they say, entitle them to set aside the facilities. They say they've done so, but they don't say when. Although in the skeleton argument served yesterday, they now suggest that they may have terminated, accepted a repudiatory breach, rescinded the contract simply by non-payment of the sums due under the facility. We say that doesn't work at all, because what they did at the end of the day in July, August 2019 was they wrote to the banks and said, we can't pay, we need to refinance the existing facilities. They didn't say we're not going to pay because you haven't provided working capital. So they do say that the guarantee of working capital became a collateral contract, and they also say that it was an implied term of the facility agreement that this collateral contract would be performed. Now, we say that's completely impossible to follow logically as an argument, but the point of the argument is to allow the defendants to say, well, because you breach the collateral contract, that gives us a ground to set aside the facility because they bind it into the facility. But it's pure assertion. There's nothing in the facility that could give rise to that sort of implied term. So we say none of this raises a real prospect of successfully defending the claim. And I'm just going to summarize very briefly why, and then I'll come on and deal with this in a bit more detail. First, we say you can decide today or in your judgment on this application that the guarantee that's alleged of working capital just plainly wasn't made. We can say you can reach that conclusion now. We've got contemporaneous documentary accounts of what was agreed at that meeting from both sides and between them. And there are no documents, there isn't a single document which indicates the sort of commitment of any sort to provide working capital, right up until you get the defence years later. Now that, we say, would just be inconceivable if it had happened. I mentioned the documents that my learned friend or the defendants produced yesterday. We say that that just only adds more support to the claimant's position on this, because what it shows is the defendants going around after the facilities are arranged, trying to arrange working capital on a bilateral basis with various other banks, but they don't approach Noor at all. So the documents, the absence of documents, and the conduct of the defendants all demonstrate that there is nothing in this allegation. But the second point is that even if the defendants could establish that some sort of commitment of that sort was given, it would only get them so far as a commitment from Noor. The defendants have no case on agency. So if Noor said it, only Noor could be responsible for it. And the defendants say that actually the claimants, the other claimants, were not aware that Noor had taken security over the OBN assets. That's their position. Makes it very difficult for them to suggest that Noor was an authorised agent. But when you look at the basis on which they assert that there was agency, you've got an assertion of an understanding from the chairman, which amounts to nothing. And then you've got reliance on various other documents, including in particular this IMLA letter, which is the appointment of the bank as an arranging agent. Now, we just say that the case on that just misunderstands what an arranging agent is. An arranging agent acts for the borrower, not for the lenders. And that is also clear from the documents. So that alone, that discrete issue by itself, we say pays to all of the defences based on misrepresentation and on contract. Financing arrangements could not be set aside in those circumstances because there would be innocent parties to those documents. And so there could only be a counterclaim against Nur. It couldn't amount to a defence. Even if there was a right to set aside, we say it would have been lost by affirmation because there are drawdowns right to July 2019. And then, as I've mentioned, in August 2019, the defendants sought to restructure the facilities. That then leaves the duress case and Sharia. On the duress case, we say there are even deeper logical problems with that case. Firstly, the threat that is alleged was a threat by Nur not to enter into the syndicate, that is, not to provide finance. But that, we say, is totally legitimate, and you can see that from the terms of the IMLA letter, the agreement, because it says so in terms. There is no commitment to provide finance. My learned friend now accepts that in order to establish a duress case, he needs to show some sort of breach of duty, and the breach of duty is breach of contract. So he has to reinterpret a provision which says on its face there's no commitment to provide finance, as nevertheless allowing there to be some sort of duty to provide finance. It just doesn't work.
Well, he says there's a best endeavours clause to put the syndicate together, and that even allowing for the cases which say that you can take account of your own interest in the context of best endeavours, it's always a fact-sensitive question, and the issue is therefore how that tallies with the express provision that law was not bound itself to lend.
Yeah, well, our position is that you cannot interpret that provision of best endeavours as leading to a situation where Nor is obliged to lend unless you simply put a line through the express term of the contract. And I'll come on to it, but ultimately it is not a surprising provision in an arranging contract. Arranging banks don't guarantee syndicates. What's the conclusion of that? If nobody was interested in this financing, Noor has to come up with, what, 1.75 billion dirhams by itself. I mean, is that really what is being said? So unless you just simply don't give effect to an express term of that contract, there's no answer to it. And that is a short point of construction, which your lordship can determine on an application of this sort. It's not fact sensitive. It's an English law contract. And the second problem, one of the other problems with the duress case, is that the defendants would have to show that as a result of the threat, there was no other course available to them other than entering into the facility. But they can't say that because it's contrary to their own case. They say that but for the threat, they would have entered into the facility. That's their case. They say they would have entered into a facility on similar terms to the facility, but without the obligation to provide security over the OBN assets. But the security over the OBN assets is not part of the facility. So what they're saying is, but for the threat, they would have entered into the facility. Now, the defendants dismiss this as some sort of technical point, but in fact, it's a logical incoherence in the defendant's case, because logically, they have to say both that they would and would not have entered into the financing but for this pressure. So this comes down to effectively saying, my point is that if there was this illegitimate threat, we won't enter into the syndicate unless you provide security. The target of that is the provision of security. The target is not the syndicate, the syndication, because they say they had to do that deal one way or another. On the contract side, the argument there's a contract in it.
While we're on that point, Mr. Montague-Smith, Mr. Fraser makes a point about what's happened in terms of enforcement of the mortgage.
Yes.
And the question of sharing that amongst the syndicate members, as opposed to being retained by law in respect of its own claim. Obviously, the evidence doesn't show what the position is, but presumably you're in a position to tell me what instructions, what's happened.
Yes, so I just received those instructions this morning. This has all come up very recently because this arose as a result of the evidence that came in very late. And the answer is that the security OBN was enforced, as I understand it, to the tune of about 40 million dirham, albeit it was enforced by a third party. Dubai Islamic Bank has received part of the benefit of that, in total 22.8 million dirhams. That was not received to reduce any kind of exposure under the syndicate. It was used to pay down other, apparently, bilateral exposure between DIB and the group. So it has not been shared with the syndicate.
Yes.
That's my instructions.
All right. And was it or was it not a breach by Noor to do what they did in taking the security? Was it a breach of the syndicate arrangements with the syndicate? I mean, I appreciate the taking the security precedes the actual syndication.
Yeah, well, exactly.
Because it happened 25th of December as opposed to 27th of December and so on. But is there any question of a breach of their duty to the other syndicate members? No,
there were no duties at that stage. There's no syndicate until the syndicate is formed, which happens
on
the 27th of December. So there's no contractual duties. And I'll take you to the authorities on this, and it comes up in the context of agency, because it said, oh, well, in part, one of the things that is said, not in the way that your lordship's putting it, but in part, one of the things that is said is that there was a breach of duties to the rest of the syndicate in making the threat not to participate. And the answer to those sorts of questions is that you can, I mean, it's almost unheard of to suggest that an arranging bank owes any duties of care, fiduciary duties, any duties to the other banks. Yeah. It's the agent of the borrower offering the debt to the market. So obviously, once it's appointed as an agent under the terms of the facility documents, then it owes duties in relation to those appointments. And there will be intercreditor agreements as to what may or may not be done. But the timing is clearly critical in relation
prior to the arrangement. You say just like any bank can make its own bilateral arrangement with the debtor.
Right.
Yeah. All right.
On the contract side, as I've said, you've got my point that just saying we will provide working capital of at least 100 million dirhams, even if you make that in a way which is intended to commit you, it can't commit you. It's wholly improbable that a bank would do it in that way, orally, on the day that it's demanded. But more fundamentally, what are the terms? It's not, as I understand it, said there was a loan agreement concluded on that date. It's not said, well, the first defendant, for example, could simply send a letter drawing down on the facility. There's not an actual facility in place. So what's being said is we will agree with you the terms of a facility. It's an agreement to agree. Even now, we don't have any terms suggested. And critically, you'd have thought, what are the terms going to be in relation to security?
Yeah, well, that's fine. Mr. Fraser wants to put it in terms of representation of intention.
Yeah, but it can't get him any further than an obligation to, an offer of a contract. So I mean that's right, really. What it comes down to is essentially a counterclaim against Norbank on the footing that an unnamed employee of Norbank at a meeting said, we will give you a working capital facility if the syndicate doesn't provide one. As I say, when you look at the documents, you will see we say that that is just totally incredible. But even if you accept those assertions at face value, you don't get to a claim, because if the statement's too uncertain to form the basis of a contract, it plainly can't be a statement that a party could reasonably rely on, no matter how you characterize it as an implied representation or whatever. The same problems arise in that context. What terms are expected? What security is going to be provided? The counterclaim itself is in the vaguest possible terms. It comes down to saying that because certain security was, the OBN security was tied up with Nur, it wasn't available to be used to get working capital from somewhere else. It can't be a defence to the claim because there are particular provisions, no set-off provisions in the documents. So what you've just got is an unliquidated claim for damages for failure to comply either with a side agreement or which we say would be unenforceable, or some sort of misrep claim. So that's why we say there's just no real prospect. You can decide that today. The second part of the argument relates to the Murabha lending, and that's about 750 million dirham out of the total. And the argument goes that the Murabha element of this is void because it conflicts with Sharia principles. And those principles, it's alleged, are incorporated into the contract. Now, we say that this aspect of the defence is just totally misconceived. The Murabha agreements are governed by English law. All of the contracts are governed by English law. Now, they are expressed to be in accordance with Sharia, but there is no obligation that they should be. There's just a recital which says the parties have agreed that they are. And again, we say the defence is just totally unreal, because the contract itself refers to the Sharia. And so the defendant's case is, well, that needs to be interpreted in a way which means that it's referring to a particular set of principles, the AOFI principles, and the effect of construing it in that way is that the whole thing is void. So they're asking you to interpret particular provisions of the contract in a way which render the contract void. It's just a wholly, we say, unrealistic way to approach the construction of a commercial document. And in fact, we can show you pretty shortly the agreements were consistent with Sharia. Now, my learned friend says I'm not allowed to make that submission because you need expert evidence of what Sharia law is. And we say that submission is plainly wrong on the basis of Court of Appeal authority. You can't just say, well, this is defective by way of Sharia and then commit the parties to a trial on expert evidence. And actually, when we get into it, you don't need to resolve any conflicting issues of Sharia anyway to see that my learned friend is wrong, because it's about his characterization of the way the contracts work, more than anything about any dispute about what Sharia means. But I'll show you what I say about that.
You've got a waiver point as well, haven't you?
And we've got a waiver point as well, which he now runs a public policy argument in relation to the waiver point and the estoppel point. He says it's contrary to public policy to have the contractual agreements. So he attacks the actual clauses of the contract on the basis that they are somehow contrary to public policy. But none of that is realistic. And the other point we've got is that even if we can't rely on waiver, even if the agreements are not consistent with Sharia, it would make no difference. There's no term of the contract which requires their compliance with Sharia. There's no realistic case that the principles are imported. And actually, when you look at the particular provision, which introduced the principles my learned friend relies on, it's clear there's a grace period, and we were in the grace period in 2018. So what happened was the principles say, and I'll show you this, that when these requirements were introduced, what it said was the banks can continue to make their current offerings, but they have to put together a plan for migrating from offerings which are not to offerings which are consistent with these new principles. So there are a number of points. I mean, there's any number of points in relation to those, frankly.
I confess, obviously, not being wholly familiar with the decree, but is it a question of regulatory law, or what is it in your submission?
So on the pleadings, it's a question of contractual law. What they say is that the principles are incorporated by reference, and therefore, because there's they're inconsistent with the applicable principles, which are terms of the contract, the whole contract is void. So they're saying that the contract's internally inconsistent. It's put differently in the skeleton argument, and it may be that what's being said is, well, this is an unenforceable contract because somehow there is a breach of regulatory law. That is not expressly alleged. It's not expressly said that defendants were operating in breach of regulations, but none of that actually works in any event. My learned friend doesn't produce any case to explain why or how the particular breaches of the regulations that he alleges give rise to the avoidance of the contract. I think he says that the avoidance of the contract arises as a feature of Sharia law, or may arise as a feature of Sharia law, but ultimately he dodges the whole question, because he says, well, there's a registrar's direction out there which says you're not allowed to look at anything Sharia related. But that is wrong. But even if it was right, it doesn't mean that you can't determine the effect on an English contract, English law contract, of what would be the result if there was a breach of Sharia. So I'll go through that in a little bit of detail in order. I mean, there's obviously there's a number of different ways one could approach the order of it, because the issues are overlapping to some extent. But hopefully I've selected a logical order. But that's a bird's eye view of the case. And ultimately, my learned friend says, well, this is all terribly, terribly complicated. That is pretty much the beginning and the end of what we'll be talking about today. So we say, I mean, your lordship's been here before, you know, the 50-page defence, the 84-page skeleton argument are really just part of an attempt to make this all look much more complicated than it is. I mean, fundamentally, this is a debt claim, it's no more complex than that. So what I was going to do next was just go through the background and then lead up to the question, this factual question about whether or not there's a real prospect of my learned friend establishing at trial that there were these representations that were made. I will explain a bit about the background and take you through the events that lead up to the syndicate itself, and show you one or two of those documents. So just sort of starting at the beginning of the story, I don't think this is controversial. I think the position was by early 2018 that the group knew that it needed to refinance, and so it approached Noor Bank to arrange that. And in early May, the group prepared a term sheet, a draft term sheet, saying that this is what we're looking for. And my learned friend makes the point, and this is right, that at that stage, the group was proposing a financing of 2 billion dirhams, of which there would be provision for working capital. So there was a 300 million dirham working capital facility that was being proposed. So that we accept at that stage. Noor Bank then provides a bridge facility of 500 million dirhams. And that went through the usual process. There was approval by Noor's credit committee, then approval by the board. And then on the 1st of August 2018, Noor Bank presents its fee proposal. And this is where we can start, if we may, just looking at some of the documents. If your lordship has bundle B and goes to page 270 of bundle B, it's behind tab 9. And so you've got the proposal. I don't know whether your lordship's working just from the digital bundles.
I am essentially, yes, certainly on, apart from the witness statements and pleadings and so on, I'm working from the digital. Sorry, 209, did you say?
270.
Oh, sorry, 270.
So this is a document dated the 31st of July 2018. I think on the evidence it was sent, I think, on the 1st of August, but it doesn't much matter. And it's the proposal by Noor for the provision of a bridge facility for 500 million dirhams. And you will see there is to be a bullet repayment after 7 months. The explanation for that is, we say, that the plan was to refinance with a syndicated restructuring, and that would reduce Noor's exposure. But then collateral security, you'll see item 5, release of this facility is subject to the provision of the mandate to Noor for arranging the syndicate financing. So Noor was making clear that the bridge loan financing was conditional on Noor being appointed as the lead arranger for the facility that was the syndicated facility that was anticipated. And then we get the IMLA letter, which is provided also on the 1st of August. It's actually back in the bundle at page 260.
Yeah.
And we'll come back to this in due course, but just to orient you in the documents, this is the document by which, once it was agreed, Noor was appointed as the lead arranger, the initial mandated lead arranger. And you'll see by this point, the facility is identified as being for 1.75 billion. So it's come down from the 2 billion to the 1.75 billion. And I'll show you some documents later, but just to give you the headlines, the defendants say that the intention on Noor's part was always to reduce its exposure from the 500 million in the bridge loan to 250 million, principally through syndication. So the idea was that they would go into the market and find 1.5 billion syndication.
You said the defendants, you mean the claimants?
Sorry, the claimant's position. Thank you, I misspoke.
Yes.
Now,
were both of these documents signed?
This was certainly agreed. I don't think anyone disagrees with that. Whether it was signed, I'm not sure. The document we have in the papers is not signed.
Right.
But both parties rely on it because, amongst other things, the defendants say, well, it's the terms of this agreement which made it illegitimate for Noor to say we're not going to participate. And you can see that on page 260. So it says under the heading, it says, "Dear Sir," and then 3 lines in it says, "We are willing to use our best efforts." That's the provision that's relied on. And we point out that the very next sentence says, "Nothing in this letter constitutes a commitment to provide any financing." Sorry, your lordship's looking for something. I was just pausing.
No, don't worry.
Thank you. So in early September, then the draft term sheet for the syndication is prepared for issue, and at that stage there is a discussion between Noor and the group about whether or not that syndication should include provision for working capital. And so I want to take to the next page. I'd like to take you to, please, is page 520 of the bundle. You can pass over bridge loan facility agreements. 520. So what's happened on page 521?
Hold on a sec.
Yeah.
It's not responding. So it's not responding to my find at present.
Is it easier if I give you? No, it's probably not, is it?
No. I'm not quite sure why it's not responding when I type in on.
It's 8:41 in London, so I wonder whether or not the usual 9 AM rush is affecting me.
Not sure. Just have to do it manually to get them. Okay. 6 September.
Yes, so on the next page, just to give you context, on 521, you will see what happens is that Norbank sends the draft term sheet to the BBIH group.
Yeah.
That's on the 4th of September. And then you'll see at the bottom of the page on 520, Mr. Ijaz of the group sends an email on the 6th of September, as you mentioned, back to Norbank. And if you look down at that email, in the second large paragraph, the last paragraph on the page, Mr. Ijaz for the group says, I would suggest to include working capital and guarantee limits part of the syndication deal, because in case these limits will be arranged on bilateral basis, an assignment of already assigned contracts against working capital limits, and then I can't read the rest as well, as contracts reduced the collections for the syndicate banks and operations, bringing a challenge for us as well as for the syndicate bank. So he's saying, include working capital in the facility, and then the response comes back on the 9th of September at the top of the page 520. The discussion we've had earlier was for 1.7 billion syndicate, mainly for term exposure, while understanding that the working capital limits will be continued by existing banks or arranged by you on bilateral basis. Let us know if you have any further approvals. Then if we go down to page 524, you'll see the group's response to that. Same day, 524, dear Adnan, noted, let's close the term exposure of 1.7 billion. And then goes on to talk about something else. So there's discussion about working capital being included in the syndication. It's rejected by Norbank, and that's agreed. And then the group provides some comments on the draft syndicate term sheet, and that's at page 548. We don't need to go through what those comments are. Go down, you can see them sending the comments on page 548, and the term sheet itself is at page 554. But as I say, we don't need to really look at it. Actually, we can look at one thing if we may. Page 554 is where the draft response to the draft is. 555. You'll see the purpose. You'll see the facility amount remains at 1.75 billion, and then the purpose. The proceeds of the facility shall be used to repay in full all amounts outstanding under the existing facilities of the Obligor, to fund the reserve account, that's the FSRA, and to pay for the facility-related fees, costs, and expenses. So there's nothing now in the group's counter proposal about working capital, and even the comments that they do provide are rejected. You see that on page 569. They say 569. No comes back. We regret to inform that most of these terms are unacceptable for us. There's then a meeting. You see reference to that on page 577. And then a revised term sheet is produced. And there's a slight increase in the proposal, which is up to 1.85 billion. You see that, and the term sheet is at page 585. That is the final term sheet, which is produced for the syndication. That's the terms that have been agreed as to what will be sought in syndication. And you'll see it's stamped by the first defendant. And again, at 586, you see the amount has gone up to 1.85. And you'll see the proceeds of the facility shall be used, and it's the same provision and no provision for working capital. So by the time that the term sheet's concluded or agreed, it's perfectly clear the group has asked for provision of working capital in the syndicate. That's been rejected, and that rejection has been accepted and agreed. Now, the amount of the syndication, 1.85 billion, is of course a target. There's no syndicate at this stage. The term sheet then went out to the banks in early October, and then commitment letters start to come in after that. Now, I'm just going to pause here to address a couple of factual assertions that are made in my learned friend's skeleton argument. If your lordship has the skeleton argument, it is worth turning up 3 of those paragraphs. Paragraph 22 being the first. And it's a feature of the skeleton that what starts as, frankly, speculation is elevated subsequently later on in the document. It's repeated and then elevated to being an assertion of fact later in the document. And in paragraph 22, you will see what happens, what's being asserted. So they say that the reduction of the proposed syndicated facility to 1.75 billion is question begging, they say, given that it was contemplated as being 2 billion. Equally question begging is that this 250 million reduction and critically removal of the facility's working capital element does not appear to have provoked a reaction from BBIH Group. Well, that's simply wrong, because we've seen it did provoke a reaction, and the reaction was, please, can you include working capital? And the response was, no, we're leaving that for a bilateral basis. Answer noted and agreed. Let's move on. We'll deal with that another time. And so what starts as a question, was the BBIH Group being told orally at that time not to worry because working capital would be arranged separately? It said there's some support from this in the documents from September 2018 set out below. Well, I'll deal with that. But as things stand, the defendants do not know what happened to cause the reduction of the facility without seeming complaint. And then goes on to say, well, we need documents and we need cross-examination. So they accept they don't know what happened to cause the reduction, but then they feel able to make the submission that it might have been the case that there were some sort of side promises being made along the way. That, we say, is simply the invention of facts in submissions. It starts as speculation, but it is repeated in the skeleton argument with increasing confidence at various places. And by the end of the document, it is simply asserted as a fact. In reality, there is no allegation, let alone evidence, that any side promises have been made. It's just an invention in these submissions. Now, as to the documents, if we go forward to paragraph 35, which you'll find on page 17, my learned friends say that there is some support for what they've said, that there were these side promises, or there was some agreement or some understanding that the banks would provide working capital. And they cite the support in documents. And the documents they refer to, you will see in the footnotes to paragraph 35, are an email and a spreadsheet that were attached. And what they say is this was a document from Noor Bank, which appears to indicate that working capital facilities would be provided by the banks, including Noor. And we just need to go to the documents to see that they've just been completely mispresented by my learned friends. These are not Noor's documents. These are the defendant's own documents. We need to go to page 631 to see that. So this is the email that is being referred to as providing support for the proposition that Noor was contemplating providing working capital. Page 631, if you have it.
Yes.
It's 2nd of October 2018, and you'll see, Dear Misbah, hope this finds you well. We were earlier provided with the attached 2 files showing the borrowing exposure of AFM Group, Syndicate Group. While it provides a consolidated position of total borrowing, we would appreciate to have more detailed borrowing exposure that should cover the following for each of the banks. So what is happening is they are saying, this is a document we were provided with earlier. It explains the borrowing, but we want more detail. And if you go down in that, that is the document that's being referred to as paragraph, is at page 634. Do you see that? And so what's being said is, oh, well, because there's this spreadsheet in the Noor Bank's documents, which says future banking partners and provides for working capital, including 100 million from Noor Bank, this is somehow indicative that Noor Bank had agreed that that is what it was going to propose. Whereas in fact, what we can see is that this is a document that's been presented to the bank by the group and is now being recirculated in October because it contains information about the group's consolidated borrowing, and the bank needed more information about it. This is not the bank holding out that it's going to provide working capital. This is not indicative that there was some internal agreement or some internal authorization to do that.
So this document itself at 634, you're telling me is not a bank document, but it's in fact a BBIH document.
Yeah, quite. So you can see it. Look, page 631.
Yeah.
There are 2 attachments to the email that's been forwarded.
Yeah, I saw that. Yeah.
Bank borrowing and Noor bank borrowing and settlement plan. And then below, those are the same documents that have been provided in the email below. And it says, we were earlier provided with the attached 2 files. So you've got an email from Adnan Khan, who was at Noor Bank, saying we were given these documents. And you'll see, for example, if you go down to page 635, what it's providing is loan outstanding as of June 2013, 2018, bank-wise principal payment. It's a list from the group's side of their creditors, of their banking creditors, and all the banking and all the working capital they've got. So it's simply being forwarded because, in fact, the target of the forwarding is not the document that my learned friend relies on. It's the other document, because they're saying, well, look, you've got these outstanding loans. We need information, more information about them. So you've got 2. One is in June 2013, and then you've got one on the 18th of September 2018. So my learned friend just blithely asserts that this is an internal Noor document in his submissions, but it's clear from the documents that that's not what it is. And the other point that my learned friend makes is when these commitment letters start coming in October, those commitment letters refer to there being a prospect of working capital. And he refers to a couple of the commitment letters in particular, one at page 643 and one at page 647. But those don't take the position any further. If you look at, for example, the 643 one, that's one from Emirates Nbd. My learned friend refers to, for example, the fourth bullet point on that page, which says assignment of cash flow should be 100% and syndicate may agree to release part for any bilateral working capital facilities. So the mere reference to working capital facilities in that sort of document doesn't go anywhere. We can accept that the group wanted to arrange working capital facilities, but this is prayed in aid of some sort of case that it was anticipated in the run-up to the December meeting that Noor was going to provide it. But it doesn't do that at all. It's just providing conditions for the loan agreement and saying, well, BBH, the group, is entitled outside the securitization to arrange working capital. Because like any secure restructuring financing, you're going to have restrictions on what further borrowing the group is entitled to get. And so, for example, if you go into 647, which is the other example that's relied on, this is National Bank of Fujairah commitment letter. My learned friend relies on paragraph 12 of that. The working capital cap should be at 500 million. So these are just the normal sorts of things you would see in discussions about a refinancing, which are what are the limits of borrowing which the group can enter into beyond what's in the syndicated facility. Answer, yes, working capital, but the National Bank of Fujairah is saying that should be limited to $500 million. So that we say there's just nothing in the documents which, contrary to my learned friend's submission, could indicate that there was any commitment, any promise, any assurance, any suggestion up to this stage that Noor Bank was going to provide any working capital. Now, we get to mid-December or early December, and the total interest from all of the banks, including Noor, assuming Noor was going to continue at its current exposure, 500 million, the total interest is 1.75 billion or thereabouts. So it was short of the target of 1.85. But it's just worth looking at the internal position within Noor Bank on the 10th of December. And this is recorded in an internal memo. It's 4 pages on from where we are in the bundle, and it's page 651. So this is a note or a memorandum internal to Noor, yes, but from corporate banking who are arranging this or running this to the credit risk department. I don't know whether your lordship's, this is one of the documents your lordship's seen.
Yeah, I've seen everything you've shown me so far is, I won't say familiar, but I've read it.
Thank you. All right. So this one is saying corporate banking, writing to credit risk, explaining where we are and where we're going. Bridge finance facility of 500 million was approved by the credit committee and the board executive credit committee, that is, on the 3rd of July and 29th of July, respectively. This 500 million 9-month bridge facility was for the takeover of outstanding exposure from DIB and CBD and to restructure the balance sheet. The bridge facility was to be repaid through one of the following options. And you'll see option 1, syndicated facility of 2 billion. Option 2, in case option 1 doesn't materialise, this bridge facility shall be converted into a bilateral term facility for 9 years. I don't think I need to show you the next paragraph. But if we go down a paragraph, during this time, we approached banks to participate in the syndicate and have received the commitment from banks up to 1.75 billion. The syndicate documentation has already been released to these banks and are expected to be signed off by 20th December, and the funding will be done within December. Through this syndicate, majority of the AFM group borrowing is being reprofiled. However, there would be a few bilateral relationship banks continuing working credit and term exposure. The group is targeting to restructure this bilateral exposure with these banks that have overdues that is being reprofiled. So there's existing working capital facilities, those are being restructured bilaterally. While the syndicate would be bringing fresh liquidity of about 40 million The promoter has undertaken to inject equity of 100 million through Noor Bank to support the business and to manage the repayments to these bilateral banks. Out of this planned equity inject, 40 million would be provided before the funding of the syndicate and the remainder before the end of March. To secure this commitment, that is the commitment for further equity, Noor Bank has negotiated to take custody of shares of a DFM listed entity valued at 255 million owned by the promoter. These shares will be kept until such time as fresh equity is injected. So that's a separate piece of security that they're going to propose they take. And then this is the important bit, while Noor is entering the syndicate with its exposure of 500 million, we are targeting to reduce our hold to 250 million after the closure of the syndicate. A few banks have shown their interest to participate in the syndicate through secondary market that would be used to scale down Noor's participation to 250 million. However, in order to further secure our existing participation, we are targeting to take additional collateral to the tune of 150 to 200 million until such a time as we are able to reduce our exposure. The group owns oil tanks and related storage facility OBN Oil in Hamria that will be provided as a side collateral. As soon as Noor will be able to reduce its participation, this collateral will be released. And then there's a note in the next paragraph. At the time of the approval, the group was targeting total syndicate deal of 2 billion. However, that was later reduced to 1.88 as working capital relationship and a few smaller exposure banks were kept on a bilateral basis. So the point where we are at this stage, and this is on the 10th of December, so very shortly before the meeting, in order to reach 1.75 billion, Noor is going to have to keep its commitment to participate in the syndicate and so turn its bridge loan of 500 million into a syndicate participation of 500 million, which is more than it wanted. But in order to do that also, it's going to have to give up the security that it already has and hand that over to the syndicate. And that is that security is over a labour camp, which is the prime asset of the group, and that secured the bridge loan. To be comfortable with that and to continue its commitment, its exposure at 500 million, it wants further security in the form of the assets of OBN. And there's one other internal document to show you before we get to the meeting. If we go to page 655, again, this is an internal document within Noor Bank. And just to show you one small piece of this, you'll see underneath the numbered paragraph, the total amount from existing banks is 1.25 million, 1,250 million, excluding Noor Bank. Noor's commitment under the bridge is 500 million, so the total amounts to 1,750. As per internal approval, Noor's has to achieve a final hold of 250 million in the syndication, for which we are discussing with a few potential banks, and anticipate this to be achieved by middle of April 2019. So it's clear that Noor at this stage is concerned, internally at least, about reducing its exposure. There's a degree of misquotation in my own friend's skeleton argument about some of this evidence. Again, if we go back to the skeleton, just to clear one thing up. Paragraph 25. You'll see, paragraph 25, my learned friend says, Noor Bank's case is that despite committing to provide 500 million, its intention was always to reduce its exposure to 250 million when participating in an eventual syndicated facility. We can skip the next sentence. He said, my learned friend says, this seems to have been the view of some internally within Noor Bank, but not everyone. There appears to have been some disagreement as to whether participation in syndication was in fact intended to be at a commitment of 250 million, and then refers to an internal email. That's a partial quotation from the email. The email itself is at page 671.
Who's Idris?
Sorry, who's Idris?
Informed Idris.
Oh, I think he's on. I don't know. I think he's on the executive credit committee of the board.
Okay.
But I'm not sure. I can check that for you, my lord. But then on, you've got, this is the 16th of December. So what my learned friend tries to make a point about this email and says, well, this email shows that there's doubt about whether the plan was to reduce. In fact, what it's saying is there's doubt about the viability of reduction within a certain time frame. So what the email says is, I do not accept the premise of an April 2019 sell down deadline. This is a completed credit and will require further effort to sell down. So the concern within the bank.
Where are you quoting from?
Sorry, this is page 671.
Yes.
This is the email that's referred to.
Yeah, I'm sorry, I'm not with you where you're looking at there. In the
page 671 at the bottom. I apologise. Hamid Butt.
Oh, Mr. Butt. Okay. Yeah. Yes. Okay.
So this is the email that's quoted, and Mr. Butt is sending the email to the other members of the corporate banking team and saying, second paragraph, I do not accept the premise of an April 2019 sell down deadline. This is a completed credit and will require further effort to sell down. So if you take the first half of that email, my own friend says, well, that shows that there wasn't a plan to sell down. But when you read the second half, you can see that the doubts that were being expressed were about the timelines, not about any whether there was a need to sell down. So actually, when you place this email, when you read the whole of the email, it reinforces the position that on the very day that the bank is said to have committed to providing more financing, it is very clear that they're exchanging emails premised on the fact that the bank needs to reduce its exposure. And so then we get to the 16th and the meeting. And there are, of course, two different accounts of what happened at that meeting. And the case on misrepresentation, breach of contract rests entirely on the defendants. Well, in fact, it's Mr. Al-Mahari's account of what happened at that meeting, except that the duress and Sharia points are different. Now, your lordship has read, I think, Mr. Kazim's account of this, which you'll find at page 127 of the bundle. Sorry, Mr. Kazim Ali's account. I apologise, Mr. Ali. So if you go to page 127, starts at paragraph 60. He says the discussion was very straightforward. If your lordship hasn't read it, I'd ask you to read paragraphs 61 to 67, and it probably is to save time if you read those to yourself rather than me reading them out loud.
Yes, I've read them before, but I'll just glance through them again to remind myself. Yeah.
All right. So Mr. Ali says what happened was that that Noor made it clear they wanted security over OBN's assets if they were going to continue at the current level of 500 million. He says there's no discussion about working capital. Noor was not in a position to extend more credit because it was aiming to reduce its exposure, and we've seen the support for that. And he also makes the point that nothing that was said at the meeting could have been a binding commitment, because it's all subject to documentation. There needs to be, if credit's going to be advanced, there needs to be an application. It needs to be cleared in the normal way, as had previously happened, presumably with all the other banking arrangements, but as we can see with the bridge financing itself. Now, Mr. Al-Naheri's account, it is worth just going through it in a little bit of detail. We'll find it at tab D, starting at tab 21. If I can take you first to paragraph 8. So he starts by making clear that he delegated heavily. We see that at paragraph 8. He says at paragraph 9, my involvement in the group's work was particularly limited in 2018. He had other priorities. Paragraph 10, he says I was the ultimate decision maker. And any significant transaction could only have taken place if I approved. And he gives the example of the need for personal guarantees, and says, as such, the UBO's final sign-off and approval is required. And then he says, paragraph 15, he did attend meetings, but it was usually big picture stuff, and then he left it to his management to sort out the details. I think he says, paragraph 14, that he doesn't correspond much in writing, but at paragraph 16, he says, my involvement in the syndication negotiations was relatively limited and on the big picture strategic. He says this is the third line down, it's difficult to remember every email and conversation I had in relation to syndication, but he says, oh, but I do remember the key details. Going into paragraph 17, he says he wasn't really involved in the documents at the time. And then on the fourth line, he says, I do not remember the exact day and meeting, he says, as such, while there are some events and conversations I remember having with the banks, some not all, I do not remember the exact day and meeting at which they happened, or the precise bank representative who made the statement. And he says minutes were rarely taken. You'll note that in this case, he doesn't identify the particular individual who made the statements that are relied on. Paragraph 18, he says the employees involved in negotiations with the banks, names that Mr. Mustafa, Mr. Vic, Mr. Amit Kadyar, and Mr. Ijaz, have all left the BBIH group and are unwilling to provide witness evidence. And so he says there are a lot of details of what happened that he's not aware of, because these happen in meetings, phone calls, or emails he was not party to. He says he hopes document production will help. And then paragraph 19, he says BBIH's group's documentary records are incomplete. He says many of the hard copy documents were stolen by the then vice chairman, Mr. Khoury. As regards soft copy documents, Mr. Mustafa deleted most of his emails from the year 2018, meaning there's no record of his correspondence. So that's one individual that's deleted emails. And so you don't, in my submission, have the best start for a case which is based solely on what this individual says is his recollection of a single meeting in 2018. Now, at paragraph 28, we go down to that. He says that despite the initial optimism, the sum sought was being reduced from first, he says 2.1, but we've seen actually it was 2, down to 1.85 and then 1.7. 1.85 was in the term sheet. In fact, it was 1.75. And then the working capital and growth the syndication was meant to bring had disappeared. So he accepts that they weren't part of the syndication documents, at least by that stage. And then he says, he goes on to talk about the OBN company itself. In paragraph 31, he says that in December 2018, he received a call from Mr. Vig saying that Noor Bank wanted a mortgage against OBN, in fact, over OBN's assets. And then he says, otherwise they were threatening to ruin the syndication, and he was furious, he said. And then we get to the meeting, which starts at paragraph 35. So amongst other things, at paragraph 35, he says he met with Noor, but second sentence, I do not remember all the attendees on behalf of Noor Bank. So he can't tell us who precisely was there. Paragraph 40, he disputes the allegation that working capital was not discussed. But importantly, at the end of the second line, he says it is true that Noor Bank stated that they had wanted to reduce their exposure and stated that they did not want to proceed with the syndication at the level proposed without keeping Mujamat to themselves as security for that exposure. And then they go on and say, he says, jumping a sentence, it's also true that they said they would only proceed with the syndication if they were provided security over OBN. So he accepts that he knew on the 16th of December that Noor wanted to reduce its exposure. So there's quite a lot in my learned friend skeleton about whether or not Noor's desire or need to reduce exposure was communicated to the group, but the chairman accepts that he was aware of it. So all of that really falls away. And then at paragraph 41,
Well, I think Mr. Pjsc's point is that they didn't know before December 2018.
but why?
How significant that is another question. But that's,
well, that's my point. My point is really that you can make detailed forensic points about what was or was not communicated prior to it. But if they knew on the day, then it just adds to the improbability. If they know that the Noor Bank is seeking to reduce its exposure, it makes it much less probable that Noor is going to be saying, oh, but nevertheless, we commit to giving you another 100 million. And B, it makes it much less reasonable to rely on it. And so then we've got the bits that really matter, which are paragraphs 41, 42, and 43. So 41, it said Noor Bank suggested they look to the syndicate for working capital. Now, it's not said there's anything particularly wrong with that. Paragraph 42, Noor Bank said that they would arrange for 350 million in working capital to be advanced to the BBIH group by the syndicate after the syndication was closed, if we provided the security. Noor Bank said that they would try to arrange for up to 450 million to be advanced by the syndicate banks. As said above, they indicated the other banks would support this. It's not said there's an implied representation in that, which forms the basis of any claim or set aside. But it is a factually important assertion because, as we'll see later, it's wholly inconsistent with what happened next, which is that the group approached the other banks on a bilateral basis. And then paragraph 43, and really, this is the start and end of the case on contract and misrepresentation, really. Crucially, they also said that even if the full 450 was not arranged, they guaranteed to provide a minimum of 100 million in working capital by March 2019 at the latest. It was not something that they stated they would merely consider, but something they said they would do. So it's a promise. It's a promise. That's the way it's really described. It's not said who said that. They said it. The words alleged are not actually recited. It's just said, well, they guaranteed it. It was a commitment. So this is a matter of impression, of summarising his understanding of what was being said. And then at paragraph 44, he deals with why he thought they had authority to do this, as in authority within the bank to make that commitment. And he said he was at a meeting with senior employees from Noor Bank. When you have the bank bigwig sitting in front of you, they say they will give you money if they do certain things. You assume they know what they are talking about and believe they have authority to do the deal. Now, I'll come back to this in due course, but it's important at this point to note that this is something which, on the defendant's case, first comes up at the meeting. So it's not a situation where there is time to get credit approval within the bank or to go to the board. So my learned friend makes some points about the Fraser and Kelly case. that even if you don't have authority to do the deal, you might have authority to represent that the deal has been approved. But unless you are completely ignorant of the need for an 100 million dirham loan to be approved by credit committee and at board level, if you ask for it on the day, you can't be saying that there's somebody's gone off and got approval for this because you're sitting in a room with them. But generally, the first point is that we say that this account, that there was this commitment that was given, is just incredible. And there's a few reasons for that. The first reason is that there are no documents whatsoever to support it. There is no trace of it in any document until you get to the defence and counterclaim in these proceedings. It's not recorded anywhere. It is not even mentioned in correspondence between the parties. It appears not to have been mentioned in any documents internal to any of the parties, including the group. We've seen that there are allegations that hard copy documents were destroyed and one individual's documents were deleted. But it's not said, for example, Mr. Vick deleted his emails. So Mr. Vick, who was at the meeting, has not mentioned this alleged commitment, this important commitment to working capital in any document. That in itself, we say, is a powerful problem for the defendants. It is simply inconceivable that a bank would give a guarantee or a commitment to provide or a promise to provide at least 100 million in working credit. And that should not be referred to even once. And that becomes all the more incredible, this is the second point, when you see what was discussed in the documents, because both parties went on to document the agreement which was made at that meeting. We need to go back to Bundle B, and I'll take you through this if I may. We should be in Bundle B, actually. It's page 697. So this is in the middle of the page. You'll see an email from Mr. Amit Padiyar, and it's dated the 19th of December 2018. So it's 3 days after the meeting, and it's sent to the corporate banking team at Noor Bank, and it's copied to various other people, including Mr. Rishi Vig and Mr. Ahmed Mustafa. And Mr. Padiyar was not at the meeting. Mr. Rishi Vig and Mr. Ahmed Mustafa were at the meeting. And what Mr. Padiyar says is, Dear Adnan Naqvi, during your meeting with our Group CEO and Group CFO, we have agreed the following. 1. Free zones as an additional security to support Noor Bank existing loan exposure and advanced facility management. Noor Bank will release the charge on the OBN facility if it is able to sell down its partial exposure by 31 March 2019. 2. To pledge our shares in Gulfa, subject to bringing in fresh equity of 70 million in the business. Noor will release the pledge on shares immediately on satisfaction of the agreed equity infusion. You'll recall there was discussion of that listed company being the shares being pledged. And then finally he says, Noor Bank to share the draft side agreements in line with above for our review. As agreed, we will proceed with the above mortgage of assets and pledge of shares to enable facility documents sign off by tomorrow. So it is a clear record from the defendant's side of the whole of the scope of the agreement that was reached at the meeting. Now on this, in their skeleton argument, the defendants raise 2 points. The first point is it's probably worth looking at in their skeleton. If you go to paragraph 101 on page 44. So 101 subparagraph 2, they refer to this email and they make 2 points about it, A and B. The first one They say, as noted in paragraph 51 above, Mr. Paddyar's email exchange with Mr. Khan is in fact supportive of the defendant's case. So we have to go back to paragraph 51 to see why they say that. If we do that, you'll see that's on page 22. They say Mr. Amit Paddyar of the BBIH group emailed Mr. Khan and Mr. Naqvi of Noor Bank to formally document an agreement which was to go alongside the provision of security. It describes the agreement, then says Mr. Khan sought legal advice on this internally, and then says provided a draft text of a letter. The draft letter provided 250 million at an acceptable level for Noor Bank's participation. Mr. Paddyar replied, amending the amount of the acceptable floor up to from 250 to 350 million. This 100 million dirham amendment is the exact same amount as Noor had promised it would offer by way of working capital outside the syndicated facility. So what they're saying is that this document that I've just shown you on page 697 is somehow supportive of their case, because later in January, the threshold for releasing the OBN security was increased from 250 million to 350 million. But that doesn't say anything about, or doesn't explain why there's no reference to working capital. And there's no reference to working capital in the January exchanges either. But 3 days after the meeting, you've got a complete record of the agreements, which says nothing about working capital. And yes, there's discussion subsequently about what the threshold will be for the release of that. But it's got nothing to do with, and doesn't support any suggestion that there was some further agreement in relation to working capital. And anyway, as I say, that agreement or those discussions about where the threshold should come for the release of that security, 250 or 350, they come on the 8th of January, 2019. And when you look at it in response to, in actually what's being discussed when you come to those, and we've got to skip forward in the bundle, I'm afraid, to page 1042. If you have 1042,
Yes.
You see the email from Adnan Khan, which is part of the discussions, and it's in response to this that the group tried to change the threshold to 350. You'll see what Mr. Khan says, page 1042, just under the numbered paragraphs. Please note we had agreed to release the mortgage as soon as reasonably practicable after our exposure under the facilities is reduced to 250 million, and to release the pledge as soon as reasonably practical after that, after the further conditions satisfied. So the suggestion seems to be that the document I showed you at page 697 is supportive of the case because later there was some sort of attempt to amend it. But when you actually look at those documents themselves are inconsistent with the case that's being advanced. So the first argument for why you can just look past what is on its face a complete record of what was agreed 3 days after the meeting it just doesn't get anywhere. And the second argument, which is the B in paragraph 1012 of the skeleton, was simply that Mr. Al-Mahari says he doesn't think Mr. Paddyar was at the meeting. But he's already said he doesn't remember who was at the meeting. But the email that I showed you at 697 is copied to Mr. Rishi Vig and to Mr. Ahmed Mustafa, who definitely were at the meeting. And clearly the details that are provided of the agreement are accurate. The defendant's case just has to be they're incomplete. But the only realistic conclusion from that document is that it reflects the views of the group's management as to what was agreed at that meeting. just to pick it up again, to show you the rest of the documentary trail that comes after the meeting. If we go back to page 697. So I've shown you that document recording from the group's side. You then see above, there's a chasing email from Mr. Padilla. Dear Adnan, please can you share the draft of the side agreements? And then page 696, you see this is a NUR internal correspondence, which is NUR's corporate team sending or asking legal to help prepare these side agreements. And so it shows NUR's understanding matches that of the groups. This is bankers emailing their internal in-house lawyers. So this is a record, their record of what was agreed. And so you can see both sides agree that that is what was the thrust of the agreement, subject and seeks those side agreements. And then there's so you've got the view from the group, you've got the view from the bank, and then there's inter-parties correspondence as well. And we see that on page 700. So this is December the 20th at the bottom half of page 700. We say, therefore, 4 days after the meeting, and you've got an email from Noor Bank to Mr. Padilla, copied to Mr. Vic, it's not at this stage, I think, copied to Mr. Mustafa yet. And what it says is, dear Amit, as discussed just now, PFA, the letters as per DFM format, which need to be signed. So that's separate. That's in relation to the share pledge. These were earlier shared with Sridhar. That's PFA, I think, means please find attached. And then the second provision here, you'll see, kindly arrange to have these signed at your earliest. Additionally, as discussed, we are arranging for the side agreement. Please proceed with completion of all documents simultaneously. So that's from both the syndication and the side agreement. They want it all done at the same time. So again, it's abundantly clear. They're saying we want everything documented now, and this is what needs to be documented. This is a complete record of what has been agreed. That's on the 20th of December. Then you'll see in the middle of the page, what happens is Mr. Khan, 4 days later on the 24th of December, forwards this to Mr. Ahmed Mustafa, another person who was also at the December meeting. And he says, we need your support for the sign-off of these documents, preferably today. And then you get a further email from Mr. Khan to Mr. Mustafa, confirming once again what was agreed. Dear Ahmed, confirming the following. Call for shares to be pledged, OBN assets will be mortgaged. And then this has been our agreement with you and will be incorporated in a side agreement that my lawyer is drafting. And then explains why there's been delay.
So sorry, could I just have a page reference where you are now?
Page 700.
Thank you so much.
Sure. And
the bottom email,
yes.
what's PFA?
Please find attached.
Oh, right.
Well, that's my interpretation, I should say. It's not a term of art. So there's two parts to it, as you know. One is the Gulf for Share pledge.
Yeah.
And then the other is the OBN security. And what they're saying is, we want all of this. We're arranging for the side agreement. We want all of it signed off at the same time. That is the side agreement. That is the collateral agreement between the parties. And my learned friend's skeleton argument, all 84 pages of it, says not a word about this document. So we say it's clear as day that that is what was agreed. In fact, the contract didn't happen quite at the same time. I think the security was arranged on the 25th. These side agreements were not yet agreed. Syndication was then agreed on the 27th of December. And then in January, there is further discussion about the terms of these side agreements. And we go down to the documents. I've already shown you part of them at 1051. And these are emails between Mr. Khan and, on the other hand, so in the middle of the page, I've already shown you this part of it. 1051, I think, Adnan Khan is emailing Mr. Mustafa and Mr. Vig again, both of them at the meeting, copying Mr. Padiyar. And then he says, "Dear all, following letter is being issued today, covering the Gulfer pledge and OBN security. Please arrange to send us the original executed pledge documents for Gulfer shares for us to release the original letter." And then says, "Dear sir, we refer to the following: the mortgage over plant, the proposed pledge. Please note that we had agreed to release the mortgage as soon as reasonably practicable after our exposure to facilities is reduced to 250 million, reduce the pledge as soon as practical after you agree the equity injection into the company within the timelines agreed in the facilities." So this is the agreement, and then it's recorded. What NUR does, you'll see what the group does is in the middle of the page, you'll see they then draft the side letters. Amit Padiyar sends them to Adnan Khan. "Please find attached the draft side letters. Please arrange to execute this on your letterhead." And then you'll see at 1053 is the OBN assets and the agreement. Noor agrees to release that, and then they've increased the limit from 250 to 350. There doesn't appear to have been any discussion about that. 1054 is the Gulfer pledge, which we don't need to look at. But it doesn't look like there's any landing on these side agreements. And what we say is that the defendants just don't have any credible explanation for this correspondence. What they say in paragraph 99 of their skeleton, as they suggest that it may well have been the case that Noor Bank's representatives made bold promises with dealing with the chairman, but at the very least rode back this language somewhat when dealing with his subordinates. So there's an implicit acceptance that the clear view, all of the evidence shows that the management's view of discussions, as reflected in the correspondence, is consistent only with Noor's case. But all of these people were at the same meeting. There's no suggestion that there was some sort of intervening discussion with the chairman. And then paragraph 97, if we go back a page, offers two explanations for why working capital doesn't feature in any of the correspondence. It's a fairly lengthy paragraph, but the first is really speculation. What it says is, well, it might have been the case that Noor was confident that it could sell down from 500 to 250. But I've shown you the correspondence where actually, which is also relied on by my learned friend, where it shows that there is definitely no confidence that there's going to be a sell down, and certainly they were targeting a date of April. So the idea that they would commit before April, before any sell down could be completed, to increasing their exposure without there being a single document to support it just cannot be explained in that way. But there's no evidence to support it. It's pure speculation. And the second proposition that's offered, I'm afraid, is not appropriate, because what is said is, alternatively as set out above, the court cannot rule out at this stage that Noor Bank representatives may have been making promises to the BBIH group that they knew they could not keep. So my learned friend feels able, and he goes on to use the word dishonesty, he feels able in his skeleton argument to assert a claim in deceit. It is not pleaded. It is not appropriate to introduce an allegation of that sort in this way the day before a hearing. But if anything, that simply makes the case that much more incredible, because now what we've got is unnamed employees of Noor making statements they knew were not true, and then concealing them in effect from the bank's management and from the bank's in-house upper management, that is, and from the bank's lawyers. So, for example, if we go back to the bundle and go forward to page 1098, you've got an email from Mr. Nakfi, the commercial team, emailing Umar Gufran, who is his chief credit officer. And on page 1099, you see what he says. Syndication valuing 1.725 billion was successfully closed with Noor as LMA and participant with 500 million. Our final hold has to be brought down to 250 million within 6 months from close of syndication. While our distribution desk is talking to various banks for sell down of our exposure, business team has negotiated additional collateral with book value of 238 million. This comprised of assignment of lease and mortgage over assets in Hamria Free Zone Authority in Sharjah. The land is connected with a jetty, and the understanding with the client is that the asset will be released after Noor Bank exposure on the syndicated facility is reduced to 250 million. So the case has to be that Mr. Nakfi is simply misleading his chief credit officer about the terms of the arrangements between the two parties by saying absolutely nothing. And by the way, we have to bring down the exposure, and then but not at the same time saying, but by the way, we've committed to giving them another 100 million in working capital. It just becomes more and more impossible to credit. And then you get down to what happened afterwards. So on the very next page, you will see a letter from the group on the 27th of March 2019. And it's the second paragraph of this letter. It says that the title is Request for Working Capital Lines. And it's to Emirates Bank, the global agent. So it's to the syndicate. It's not specifically to Noor Bank. It says 27th of March. As discussed, while closing the syndication, we made a technical mistake by assigning all of our projects to syndicate instead of the agreed 70% of the projects. On top of that, we overlooked the working capital requirements of the projects that are assigned to the syndicate, and then explains that that's difficult and it says, based on our internal analysis, we're requiring following immediate assistance from major participating banks to ensure smooth operations, 150 and 50 million. Now, my learned friend's skeleton argument seeks to try to explain this away. He says further evidence is required to explain the use of the word overlooked, and he doesn't refer to the word technical mistake. He says the defendants need to get further evidence about this, but the defendants have already said that evidence is not available. A colossal amount of money has been spent by the defendants in preparing for this application. You may have seen the cost schedule that was filed, which includes counsel's fees of £225,000. No stone has been unturned. That's just for the application, let alone for the preparation of the 50-page defence and the trawl of documents, which led to multiple extensions of time in the lead up to it. It's no good to simply say, well, something might come up. The document on its face is simply saying that the group themselves failed to organise working capital and got themselves into a bind by assigning all of their security. Now, yesterday, the defendants produced these new documents, which are intended to explain the overlooked language. So they are produced at the 11th hour in response to our pointing out that their own correspondence says they overlooked the working capital. Now, as we've seen, the correspondence they're seeking to explain is the 27th of March letter, and they produce an email, an internal email, which says that it wasn't in fact overlooked. That is at tab G, and you will see an email chain that starts on page 4610. You will also see that the email that's referred to, and I'll take you through the chain in a moment, but the email that's referred to, which you see at the top of 4610, says we did not overlook the working capital requirements. You will see is a response to an email sent on the 24th of March, and indeed that email itself is sent on the 24th of March, so it comes before the letter that we've just been looking at. It can't be a response to it. But anyway, if we look at the email chain, it is totally inconsistent with the case that's being advanced and totally inconsistent with the chairman's evidence. If we go down to page 4614, that's probably the best place to start. You see this is an email correspondence on the 14th of February 2019. So this is the first time you've seen it was last night, but it's pretty clear what it is. You've got somebody from NBD, so that's from the group.
I'm sorry, which bit are you looking at?
Page 4614, it's the bit at the bottom. I apologise, I should have said that. Mr. Amit Padyar.
Yeah.
Is emailing on the evening of the 14th of February, Mr. Sudhanshu Dubey. And that is someone we can see it above, who's at United Arab Bank. We'll come on to that in a moment. They're one of the claimants, but also a party with whom there are existing bilateral working capital arrangements. So the first thing that Mr. Padyar says is, in the first main paragraph, due to the delay closure of the deal, the net disbursement has been reduced to 18 million dirhams from initial expected liquidity of 35 million dirhams had it closed on the 31st of December 2018. We also made 2.9 million dirhams unplanned payment to UAB, United Arab Bank, on the closure of the syndicate. So the first point he says is the cash flow is worse than they had anticipated. And then second, he says, we are still working on to set up working capital facility for AFM, that's D1. We are making progress with a few of the syndicate banks, but it may take another 6 to 7 weeks till the facility falls into place. Now, it's not said that they ever approached Noor for working capital facility and were turned down. It's not said that they went to the syndicate as a whole or asked Noor to go to the syndicate as a whole. So just thinking about this, they say that Noor committed either to arranging, or if they couldn't arrange it through the syndicate, providing working capital. But actually, you see the group is going to other banks on a bilateral basis instead. And the whole thing is entirely consistent with Noor's position at the outset of the syndication, which is that we are not going to raise working capital for you, but you can go and raise it bilaterally. We showed you that right at the outset. So it's inconsistent with the chairman's, Mr. Al-Naheri's correspondence. So there's a request for a meeting above on the same page. And if we go up to page 4612, we see an email.
Just bear with me a moment.
Yes.
Montague Smith. Mr. Sudhanshu Dubey is CIB is which bank?
I think that's an internal denomination within Dubai Arab Bank.
Arab Bank, is it?
Yeah. And you can see that from, sorry, no, it's not Dubai Arab Bank, sorry, it's United Arab Bank. I do apologise. You can see that from page 4612. You'll see the email address is UAB. United Arab Bank is the fourth claimant.
Yes. And they appear to have a bridging loan from them.
There's a working capital facility, I think, in the background.
looking at the immediate visibility for us is to settle the outstanding bridge loan from equity contribution of 70
Yes.
million.
Yes, you're right.
Okay.
And then if you go up to page 4612, I was going to skip the bits in between. And then we see on page 4612 at the top of that an email dated 3rd of March 2019. There's a bit of a lull.
Yeah.
And then the bank get back in touch to Mr. Padilla. Hi, Amit, trying to reach you. Please call. Need to discuss details of account statements and immediate payment of 5 million dirhams. And then the response is on page 4611. There's a chase. But you see a 4611 on the 3rd of March. And you'll see, Dear Saqib, so this is from Mr. Padilla, as discussed with you, our best position is holding agreed payments against the expected equity injection in May 2019. So they're saying our best position, the best we can do at the moment, is to say wait until the chairman injects capital in May 2019. It doesn't say our best position is we need to go to Noor Bank because they promised us 100 million dirhams, so don't worry, we'll get this sorted. And then says, as you are aware, we have a few contracts outside the syndicate to support working capital limits. Please find our proposal below. So, by the way, they are offering collateral for these working capital limits, which the defendant's cases they didn't have. That's obviously central to their case because their whole case is that the business collapsed because they didn't have OBN's assets to use as collateral for working capital. But they clearly have some collateral that they can offer to try to get 110 million dirhams out of United Arab Bank. And then on the 24th of March, we go back to page 4610. We get to that email exchange, which is relied on. Mr. Ijaz then emails to United Arab Bank and says, this refers to our recent telecom. While closing the syndication, we overlooked the working capital requirements of the 70% projects. And they said we're thankful to everyone that they've understood our requirement, showed inclination, and go on to say the approval process might take a few weeks. So they say, I think, yes, sorry, in the middle of that paragraph, in the 3rd line, they say we are currently in communication with majority syndication banks for the arrangement of working capital lines for the 70% of projects. And then effectively, they beg the bank not to present the check as they cannot pay what's being demanded. And it's in that context that Mr. Rishi Vig says that's factually incorrect. We didn't overlook the working capital requirement. Our understanding has always been to get working capital after the closure of the syndicate bilaterally. So this doesn't help the defendant's case. This makes it immeasurably worse because Mr. Vig is not saying we didn't overlook it, we agreed it. He's saying we didn't overlook it, we put it back. We knew we needed it. We were always going to deal with it. We had a plan to deal with it, and this was the plan, to get working capital after the closure of the syndicate bilaterally. So this new evidence is just totally inconsistent with Mr. Al-Mahari's evidence, which is that it was agreed that Noor would get working capital from the syndicate as a whole. And this is late March. This is the 24th of March. And the letter that I showed you previously is the 27th of March. And all of it is totally inconsistent with the suggestion that Noor guaranteed that it would provide working capital by the end of March. The group is approaching other banks. It's not approaching Noor Bank until it approaches the whole of the syndicate. And at that stage, approaches Emirates Nbd. So again, there is no complaint in any of this that there's been some form of unfulfilled promise from Noor. So not only is there no trace of working capital being promised or guaranteed, it is totally inconsistent with the group's own account with the December meeting and its subsequent explanation of why working capital wasn't arranged. It's inconsistent with Noor's own internal documents where they make clear that they wanted to reduce their exposure. It's inconsistent with the inter partes correspondence, and it's inconsistent with the group's subsequent actions. And in that context, we do say it is just simply not credible to say that some unnamed person from Noor said for the first time on the 16th of December, we guarantee to give you 100 million. They would have known there had to be a credit application, credit committee approval, board approval, none of which could have happened. So that's the first point on this application. It goes to the contract claim, misrep claim, counterclaim and set aside. And we say it's just simply not credible that those things were said. My learner friend says what I have just done is an abusive process. It isn't. This is not a mini trial. We've taken an hour to look through some documents. And a mini trial, the need to avoid mini trials doesn't mean that you have to take every assertion at face value, particularly where those assertions are contradicted by contemporaneous documents. And I have in mind, and your Lordship won't need reminding, your Lordship's own comments in reference to the Easy Air case in the GFA and Hague case, the David Hague case, which we've referred to in the skeleton argument, but you will know all about that. It's perfectly legitimate on an application of this sort to say that bold assertion does not justify a trial. And if I'm right about that issue, all that is left are the points about duress and the points about Sharia, and the Sharia points only affect that element of the lending. Well, that's what I had to say on that ground, on what's been referred to as the factual issue. It's really the issue about which most complaint is raised in relation to this application. But I do say you can decide it now. I was going to move on and deal with the issue of agency, which is this question about whether or not, regardless of what was said, whether it can be, whether the other claimants can be blamed for it. And that is important because it is essential for the defence, as opposed to the counterclaim against Noor, that Noor, if it said those things, was acting on behalf of the other members of the syndicate. In the pleadings, you need to see this. It is just a bare allegation. So what we have is it's on page 37 of the bundle, and it's paragraph 55. So you have the bare allegation that the 8th claimant was acting for itself and as agent for the 1st to 7th claimants. Further, at all material times, the 1st to 7th claimants were vicariously liable for any acts or omissions on the part of the 8th claimant. So that, as a pleading, I'm afraid, is not good enough. And if you need authority for that, you have it in the case of First Rand Properties. That was a case which concerned a bare plea of agency, and it was struck out. We can see that it's in bundle E. If you want to go to it, you may not need to. It may be a fairly straightforward proposition, but it's at tab 37 of bundle E, paragraph 26.
26 or 36?
26.
I don't think we need to go there for the moment.
No, I'm grateful. The point that the judge made is that the way he put it was to say agency is a legal construct. It's not a fact, but a conclusion from facts, and then looked at the facts as to whether they made out the agency. And here, no facts are pleaded whatsoever, which could give rise to an agency relationship. What is relied on by the defence is Mr. Al-Mahari's evidence in this regard, and also the terms of the IMLA agreement. As to the evidence, you will find that in bundle D at tab 21, page 1319, paragraph 27. And you will see it's in the fourth. So it says, he says, third line down, 1319, this is paragraph 27, third line down. The BBIH group appointed Noor Bank as lead arranger and agreed a bridge loan of 500 million over Mujamat, that's the work camp, which Noor Bank used to secure their position as lead arranger. I understood Noor Bank's role as lead arranger to mean that they now acted as a representative for the syndicate banks. They were the ones communicating to the other banks and obtaining their commitments, and they were the ones who would communicate to my team on behalf of the syndicate as a whole. So he says, once they were appointed as lead arranger, his understanding was that meant they were acting for the syndicate. Now, my learned friend's submission on this is, I'm afraid, somewhat startling. Paragraph 127 of his skeleton argument. He says, it is the chairman's uncontradicted evidence that Noor Bank was authorised by the claimants to conduct negotiations on their behalf. That, I'm afraid, is just simply inaccurate. The chairman gives evidence of his understanding based on the fact of Noor's appointment as lead arranger. His understanding is neither here nor there. It has absolutely no weight whatsoever. And as to the fact, the explanation is incoherent. Because my learned friend goes on to say the evidence appears consistent with the documents, in particular the IMLA letter. So the appointment as an arranging bank is said to create an agency in favour of the syndicate. But an arranging, so starting with the general proposition, an arranging bank acts for the borrower. The bank owes the borrower duties to go into the market and find participants. And there's a helpful passage in the commentary by McKnight, which you will find in bundle E behind tab 42. And if I can just show you two very short paragraphs of that. Page 1972, 1972, paragraph 3.42. This isn't telling you anything you don't know, my lord. The arranger is the financial institution that is commissioned by the borrower to arrange the transaction. That is, put the transaction together. This will include finding the syndicate and the underwriters if required, and taking the negotiations for the transaction through to the stage where the facility documentation is signed, or in a selling down exercise, the latter date when the wider syndicate is brought into the contractual arrangements. And then if we go down to 1975, paragraph 317, halfway down the paragraph, if your lordship has for most of what it does, it's in the middle of the paragraph. For most of what it does, the arranger is acting as the agent of the borrower, which can hardly be said to give rise to any obligation of loyalty towards the lenders. Even in the documentation stage of the arranger's functions, it is very unlikely that the arranger could be said to owe the lenders a duty of care. And if it does, it is a very limited duty, and there will still be a substantial question as to whether the lenders can reasonably place reliance upon the arranger. Taking those matters into account, it's submitted that an arranger should not be considered as being in the even more onerous position of a fiduciary towards the lenders. So if you think about the position as it was on the 16th of December, there is no syndicate. So how could the arranging bank be an agent for the syndicate? There was no syndicate until it was formed by the entry into the financing arrangements. And then the other part of the allegation is that the IMLA letter itself creates an agency in favour of the claimants, and that actually also forms part of the duress claim. So, for example, there's reference to Noor Bank being appointed as the syndicate's document agent, investment agent, publicity and security agent. But if we go to the actual letter, it's in standard terms. You'll find it, we've looked at it briefly before, but it's back in bundle B at page 260. And you'll see on page 261, what is the appointment? It's an appointment by the obligor. The obligor appoints the agent as exclusive arranger and so forth, and all the other matters. Paragraph 1.2 makes it clear that no one else will be appointed to those positions.
So in which paragraph?
Paragraph 1.2, until this mandate terminates.
Oh, yeah.
The person should be appointed. So it binds them into using them as that agent in future. But then if we go down to page 267, you'll see clause 19. There are no third-party rights. So this letter can't, even if that was commercially realistic, that a arranging bank could be an agent for the syndicate prior to syndication. Even if the problem, the fact that there was no syndicate at this stage, was overcome, this document certainly can't create that relationship because there's no third-party rights. Now, my learned friend's submissions in his skeleton break it all down into two parts, so actual authority and apparent authority, and then he goes on to deal with the Fraser and Kelly type authority. There's authority to say that you have authority, and so to stop you from denying it in future. So just looking at how they put their case now, and I've shown you how it's pleaded, but let's have a look at how it's put in the skeleton. It starts at paragraph 116, page 51. And I'm sure you've read it, but just to summarize, essentially what they say is that they complain that the claimants have produced no evidence about their relationship with Noor at the meeting. So they reverse the burden of pleading. There is no pleading to respond to on this. There's no plea of actual authority. Is it even alleged that there was actual authority? And there's no pleading of the facts underpinning any such allegation. Simply by asserting that in argument there might have been actual authority is not a defence. There's a gesture towards supporting the inference of authority at paragraph 119 of the skeleton. And you'll see three factors are identified as being indicative of agency. And so number one is that between October and December, Noor sought the participation of various banks within the syndication. Discussions were primarily directed between Noor Bank and the other banks, rather than with the BBIH group. Second, banks sent their commitment letters directly to Noor Bank, and Noor Bank dealt with inquiries for the banks directly. And third, Noor Bank spearheaded the negotiations with Mr. Vig and the BBIH group negotiating teams. But all of that is only indicative of Noor Bank acting as the arranging bank. That's what arranging banks do. So that doesn't take us any further. There is, though, now an allegation of apparent authority as well, and that starts at that. I'll just show you some of this. It starts at paragraph 126 on page 54, and culminates in paragraph 129, where it's now alleged it's submitted that the defendants have a plausible evidential basis on which to contend that Noor Bank's representatives were cloaked with apparent authority by the claimants to negotiate on their behalf. It's not explained how that arose, other than by reference to the factors that I've just mentioned. Certainly no case is pleaded or even explained as to the usual factors that would be required to confer apparent authority. You'd have to show that Noor Bank was held out. That's the essential part of it. Syndicate members would need to hold out Noor Bank as being authorised in that capacity prior to or on the 16th of December 2018. And the defendants would have to explain that in relation to each of the banks. So each of the individual banks would have to make a representation to the effect that Noor was authorised to act on their behalf in making those sorts of, and that extent of that agency would have to go so far as to cover statements asserted by Noor Bank as to what they individually would do. It's inherently inconsistent if you think about it, because the allegation is that they were authorised by the syndicate to say, firstly, that they would go to the syndicate to get a loan, and secondly, that they would say if they couldn't get the loan, that they would provide it themselves. And then the third part of the argument that's put forward by my learned friend is in relation to what they say is ratification. They say there's an argument, this is at paragraph 135, that somehow the syndicate ratified the unlawful acts. And they say this on the basis that it looks like they say the syndicate accepted the proceeds of the OBN security. As I've said, factually, our understanding is that that is false. But the assertion doesn't make any sense anyway, because if you look at paragraph 135, this is all directed at saying that they have, second line, they have ratified the OBN syndicate finance package agreement. That's what they call the combination of the syndicated financing on the one hand and the OBN security on the other. But the ratification of an agreement isn't what they need to show. What they need to show is that there was ratification of the unlawful conduct, or at least constructive knowledge of it, prior to the entry into the relevant document, which would be on the 27th of December. So what they have to show is that there's some ratification of the conduct between the 16th of December and the 27th of December, and they don't even allege that. What they allege is that something happened way later, which ratifies the agreement. What's that got to do with authorization to make false statements of fact and make side promises? So none of that makes any sense. None of it is pleaded. And then the final thing they say is, well, and it's a bit of a gotcha point, is they say, well, we haven't challenged the plea of vicarious liability on this application. And what they do is they refer to the two-part test for vicarious liability, and you'll see they recite it at paragraph 115 of their skeleton argument. And just tell you that. Reference to Lord Phillips' test in the Catholic Child Welfare Society case, and they make the point that there's a two-part test. This is page 50 of the skeleton, and they say first the relationship, that is the relationship between, on the one hand, Noor, on the other hand, the syndicate, must be one that is capable of giving rise to vicarious liability. So it's usually employment. You're usually only vicariously liable for your employees, but there can be other situations where you're vicariously liable for a contractor, for example. But it's all based on what is the nature of that relationship. Is it a qualifying relationship that gives rise to the sort of vicarious liability for your actions? And then the second part is whether there's sufficient connection between the relationship and the wrong that's complained of. And so part one requires that relationship, and the only relationship that is pleaded is one of agency. It's not alleged that Noor was employed. So if the arranger, Noor, is not an agent or an employee or some contractor, which isn't alleged either, of the lenders, of the banks, then, I mean, one just has to ask, in what world are the lenders vicariously liable for the arranger's actions? It is just a totally unreal submission. So there is no real prospect, we say, of establishing an agency relationship between Noor and the rest of the banks in making this statement. And equally, there's no real prospect because and that just demolishes any vicarious liability allegation that there is, which just isn't explained at all in any event. It's a bare plea. But the result of this is that even if the statements which are alleged were made, even if they could have the force which the defendants say they have, that could not result in the finance agreements being set aside. Because these are multi-party agreements, and you cannot rescind a multi-party agreement if doing so would destroy or materially adversely impact on innocent parties. And if you need authority for that, there's authority in Snell, but we've recited it in our skeleton argument, paragraph 71. I don't think that will be challenged. I'd be surprised if it was. So the effect only of this agency point is A, it demolishes any attempt to set aside the documents. B, it leaves only a counterclaim against Nor on any basis, whatever the basis for the claim might be, because there could be no collateral contract, there could be no misrep that could be conferred on the syndicate members, and C, there could be no even as regards Nor, it could not be a defence because we have a no set off clause in the contract. That's clause 26.6.1 of the Common Terms Agreement, which you'll find at page 978 of the bundle. So by itself, the agency issue dispenses with the defendant's entire defence. And what you would be left with on that issue alone would be a claim by the defendants against Nor that Nor guaranteed working capital and didn't deliver it. Those are my submissions on the agency point. And again, there are a number of different ways in which you could do this, but I was going to move on and just deal with affirmation very briefly next, before I come back to duress, if that's all right. I think.
How long do you expect to be on affirmation?
I would say 10 minutes, if that.
Right, let's deal with that then.
Would you like a break? I'm sorry. Is that the?
That's
question?
what lay behind the question.
Yes, I thought
it was time for a coffee, but if you want to take 10 minutes, that's fine.
Well, I think if your lordship's inclined to take coffee now, then I'd be inclined to do that too, just to freshen.
Does that make sense, Mr. Fraser, to take a quarter of an hour now?
I think it certainly does, madam.
Right, we'll have a quarter of an hour then. Thank you very much.
Thank you.
So just after past sometime.
Just after past. Thank you. My lord, you are on mute, by the way, but I'll take that as instruction to proceed. Before I do, you asked me earlier, was there a signed copy of the IMLA letter? There is, in fact, a signed copy. You will see the unsigned version ends at page 269, and a copy of that page you will also find at page 273, this time signed by Mr. Al-Mahari. So I misspoke earlier when I said we didn't have a signed version in the bundle. I was going to then come on and deal with the question of affirmation. So again, this is the reason I deal with it in this order, is because this is another overarching problem which applies to all of the ways in which the defendants try to set aside these agreements, and if they can't set them aside, then there's no defence. And any argument that they can set them aside has to meet this point that the group continued throughout to act under the terms of the facilities. And so there are numerous ways in which that happened. Firstly, the Common Terms Agreement was amended in January 2019. The terms of the amendment aren't relevant, but that's on page 1056. Then what happens?
It really only matters from March onwards, does it? If the agreement, as alleged, is that the working capital will be provided by March.
I suppose that's right. I mean, in the sense, the question is, in practical terms, how long would it have taken to get it arranged? So you saw the email exchanges which said, in practice, this is going to take 6 to 7 weeks to arrange a bilateral working capital agreement. That was the group's position. So if you bring that back from the end of March, which is what the chairman's evidence is, then you probably end up somewhere in the middle of February. But yes, I take the point. So for the purposes of today, let's deal with it on that basis. You've seen the letter of the 27th of March, 2019, where the defendants thanked the syndicate for arranging the financing. And then you've got the Murabha contracts. So the first one of those is in January 2019. And then they work for a quarter, at which point the terms are rejigged. So there's another one on the 30th of April, and the last one is on the 30th of July 2019. And I don't think I need to tell you much about the law, but we put in the case of Barclays Bank and Svizzera, which makes clear that repayments of principal and interest until the party is unable to afford to do so, it is going to be an unequivocal affirmation. So the letter from the 27th of March, where they thank the group and say the mistake and overlooked, that's at page 1100 for your note. We won't go back to it unless you'd like to. So they knew by the 27th of March that they're not going to get working capital, but they carry on drawing down for 4 months. And I'll show you the last drawdown on the Murabha, which is at page 1087. Just so you've got it. So transaction request. And that's dated 30 July 2019. And you'll see that what that does in effect is roll over the entire Murabha lending into a new Murabha, which is being requested by the first defendant on that date, on the 23rd of July. So they're acting using their rights under the agreement. And then you get to page 1104, which I don't think I've yet shown you, which is sort of the end of the story as far as the financing is concerned, until we get to letters of default. So at 1104, you've got the letter. It's dated the 25th of July, but you'll see it was received on the 6th of August. And in between those two dates, you've got that Murabha, or just before, in fact, you've got that Murabha transaction request. But then on the 6th of August, we receive, or Emirates Nbd, the global agent, receives the letter saying, I'd like to thank you for your continued support in regards to our ongoing banking relationship and the existing facilities that have been made available to the BBIH group and or its subsidiaries, and then explains the difficulties that they're having, and then goes on to say we need financial restructuring, and second paragraph, third line down, this will provide restructuring options in regard to the existing facilities. So they're saying the debts, they acknowledge the debts that arise under those facilities, and saying we need to enter into a new arrangement to restructure those. And not only that, it's not only the positive acts, it's also the fact that it is then years before they say we rescind, and by that time, of course, notices of default and so forth have been provided. Now, there are two answers given to this in my learned friend's skeleton argument. The first is at paragraph 186, subparagraph 1. And what he says is that a party is not held to have elected to affirm a contract unless he has knowledge of his legal right to choose between the alternatives open to him. And then the chairman's evidence is that he does not have knowledge of his legal right to choose between the alternatives open to him. So he's saying he's promised 100 million dirhams in working capital in December. He's not provided with that working capital by the deadline in March, and he just has no idea that the result of that is that he has a right to terminate, even though he now says he does have a right to terminate. Again, it is in a sense a factual point, but we say that it is simply incredible. The idea that by July 2019, he should be taken to have no knowledge that he might have legal rights or remedies, and the right to terminate being one of them, is just fanciful. This is not a concept that's specific to English law. And it's not the chairman's knowledge, it's the group's knowledge that is required. It's the first defendant's knowledge. And he's saying he personally didn't know. Well, one might say, well, so what? You've got a group of companies, in particular first defendant, who is surrounded by advisors. It's said to be a group that's worth billions, and yet, you know, you just basic rights are not known. So that's the sort of sum of the defence, or the response to this point is just not credible, and it's his particular evidence about what he did or didn't know it isn't going to be sufficient at trial. The second point that's made is that apparently the defendants were strung along. They say that there were repeated promises at critical points that working capital would be provided, but none was forthcoming. And in particular, there's reference, for example, to a meeting. In fact, it's on the previous page. You'll see there's some minutes of a meeting, and clause, and it's on the it's in May, 14th of May. So the minutes start on page 1101. Some of the syndicate members are there, some are not, and then you'll see paragraph 6 of the minutes at page 1103. All banks unanimously agreed to provide approval for an aggregate of 150 million working capital limits by 31st of May 2019. However, limits will be released for utilisation once equity infusion of 25 million is routed through the bank account and funds will be used for removal of downgrades. So it's said, oh, well, this was a promise to provide working capital. It's not said it's a binding promise. So again, puts a little pressure on the case that what was said orally without any record at a meeting in December was binding, but this wasn't. But it's just said, oh, well, this is one of the ways in which the group was strung along. But it's not said, for example, that the group reserved their rights to terminate. And so it really is neither here nor there what was said or wasn't said. Obviously, our factual case is that there was no stringing along. There was simply an agreement to provide working capital on certain conditions which weren't met, but we don't need to go there. It just doesn't get them to a response to the affirmation case. What they also say is that a failure to perform could be construed as accepting a repudiatory breach and terminating. And I mean, there's any number of responses to that. A, failure to perform comes later, but B, I mean, we say that just lacks all reality. It's right that in the right circumstances, not performing can mean an acceptance of a repudiatory breach. So one can imagine the situation where you get a contractor to work on site, you tell the contractor, I'm not going to pay you, and they don't turn up. One can see that might be a situation where they're not turning up is an acceptance of a repudiatory breach. But it all depends on what is conveyed by the non-performance, and what is conveyed, I've shown you, is at page 1104. We can't pay, we're not able to pay. The reason why we're not paying is not because of your breach, it's because we can't. And by the way, we need to restructure the existing facilities. So I mean, that's another point that's been raised in argument, and it's just has no, I mean, it's just not a realistic one. So the result is that you've got a contract that has been affirmed multiple times after the alleged date of default, and so you know, there's no prospect of setting aside the agreements. There's just going to be a counterclaim, which is not going to be a defence. That's all I was going to say about affirmation, and I was going to move on to look at the three discrete points. So duress, contract, misrep, and then come on lastly to deal with Sharia. And just so you know, I'm making reasonable progress, so we should be on time. In terms of duress, we say there is just no coherent case at all. And the first part, which is now admitted, is that to amount to duress, a threat has to be illegitimate and unlawful, And so the headline point really is if you threaten not to contract, that is perfectly lawful unless there's some other contract out there which obliges you to contract. And there's plenty of authority on that. And in particular, we refer just to a passage of Chitty. I don't necessarily need to take you to it, I don't think, but I'll give you the reference in case you want to look at it. It's paragraph 10-063G, and you'll find that on page 1677, which is in bundle E behind tab 33. But I think the defendants in their skeleton argument make clear that they do not allege lawful acts duress, given the changes in the law that there have been. So two arguments are raised in the skeleton argument, and they are set out in paragraph 66. Sorry, in the defence, I apologise. Paragraph 66 of the defence. So we were in it, but we have to go to page 40. So paragraph 66 is where they plead out why it's unlawful or illegitimate. So so the economic pressure exerted was illegitimate in circumstances where it was in breach of that's NOR's duties to the other proposed participants in the proposed syndicate facility, including the claimants as their agent, including as documentation agent, investment agent, publicity agent, and security agent, pursuant to the terms of the IMLA letter. Now, I've addressed you on the agency point. I won't repeat it. There just was no agency relationship. And then the second way is paragraph 66B, breach of Noor Bank's obligation to use best efforts to arrange and manage the proposed syndicate facility pursuant to the IMLA letter in circumstances where, rather than taking all steps in its power capable of producing the desired results, being the steps that the prudent, determined and reasonable IMLA would take designed to achieve that result, it made the withdrawal threat, which was no such step, but rather a step which risked preventing the proposed syndicate facility from proceeding. Now, defining it as the withdrawal threat is obviously tendentious, because that implies that there's some commitment already from which one is withdrawing. And of course, our position is that there was no commitment. And so that, we say, is just all you have to do is read the first two paragraphs of the IMLA letter to see that it doesn't work. Now, we've been over this to some extent. I won't labour it, but it's page 290. Stop. 260, I do apologise.
Of what?
Of bundle B. 260. B tab 9.
Oh, sorry, right.
So this is the source, as we said, of the obligation, the breach of which is said to amount to the illegitimate threat. And there is this obligation to use best efforts. Now, the obligation, obviously, of that sort is broad and could be interpreted, depending on the circumstances, in a number of different ways. And so the next sentence clarifies precisely the limits, some of the limits, of that obligation. Nothing in this letter constitutes a commitment by the IMLA to provide any financing. And we've discussed the way that the defendants put this, and if you look at paragraph 144, they say the purpose of the second paragraph, properly construed, is to make explicit that the letter is not in itself a commitment to lend. So if the letter is not in itself a commitment to lend, then, and there's no other contractual obligation identified as conferring a commitment to lend, a threat not to lend is not a breach of the letter. But so it's just impossible. I mean, I think that just illustrates that it's really impossible for the defendants to run this argument without just literally putting a line through an important and commercially obvious term of the appointment letter. They go on to say, I mean, effectively, you have to define that out of existence. And as I pointed out, at its extreme, the defendants would presumably say that if there was no interest in the syndicate at all, best efforts would require NOAA to provide financing. If that's not the position, then how much, at what stage do they stop? Is it saying best efforts mean you've got to fill a hole of 50 million? Best efforts, according to the case, is that we have to fill a hole of 500 million. But as I say, the answer is that these sorts of letters never include an obligation to lend, because otherwise the arranger is guaranteeing the finance. Paragraph 145, they seek to, of their skeleton, they seek to support this argument by basically saying, well, look, it would be absurd if, despite Noel Bank being under a stringent obligation of best efforts, it had total freedom to abuse that appointment. Well, that's just a circular argument. It's only an abuse if the act is unlawful. It's only unlawful if NOAA is obliged to lend. The basic point is this, really, isn't it? That as a result of the interest in the market being insufficient, the defendants needed NOAA's participation as a lender to make the syndication work, not as an arranger, as a lender. And NOAA was happy to lend, but would only do so on terms which it agreed, which included bilateral security. That's not abusive, that's just a commercial negotiation. And absent, I mean, unless they can just read away that statement in the IMLA letter, the duress case just doesn't get started. The second point here, we say, is equally clear. So the threat that's alleged is that NOAA will not participate, and so there won't be a syndicate. And so as a result, they have to say, of that threat, they had no reasonable alternative but to enter into the contract which they are seeking to set aside. But the contract is the very thing that NOAA allegedly threatened not to enter into. So we just say there's a logical hole, because I put it as shortly as I can. You can't be pressured into agreeing a contract as a result of someone threatening not to agree that contract. It's logically incoherent. So as I mentioned at the outset, the true substance of the complaint is that they say they were forced to give the OBN security as a result of the threat not to contract. So this allegation of duress could only impact on the agreement to provide that security. This point is illustrated by the pleadings. We go to bundle A, back to where we were, but go up to paragraph, so down to paragraph 131. It's on page 58.
Sorry, we talked about the skeleton or the
Sorry, this is now the defence and counterclaim on page 58 of the bundle, behind tab A3.
Yeah.
Paragraph 131, they talk about the losses which resulted from the unlawful conduct. Yeah. And they say in the middle of the page, paragraph 131, sixth line down, they talk about in circumstances where, but for the matters complained of in this defence and counterclaim, the defendants would not have entered into the OBN security finance package agreement and the syndicate facility agreements, but into a syndicate facility agreement on similar terms to the syndicate facility agreements without the obligation to procure that security be provided in relation to OBN Energy, with the consequences that the defendants would have had available to it, OBN Energy, to raise sufficient working capital. So what they are saying is, but for the threat, they wouldn't have entered into what they call the package, which is both the syndicate facility and the OBN security. They would have instead entered into a syndicate facility agreement on similar terms, but without the OBN security element. The OBN security element is no part of the facility. So in other words, what they're saying is, but for the threat, they would have entered into the facility. So the threat doesn't make a difference to them entering into the facility. It makes a difference to them entering into the OBN security. Now this, my learned friend describes this point as a technicality, a pleading point. It isn't. It's a logical incoherence in the defendant's case. And then that leads into this to the final point on this, which is that ultimately reinforcing my second point, that this is about the OBN security, not about the finance agreements. Now my learned friend has a response to this at paragraph 157. He relies on a case called MAN, sorry. And so he, in that case, when one of the swaps agreements was set aside, or all of the other agreements were also capable of being rescinded, and the reason for that was that the two contracts were structurally interdependent, because there was an obligation in the loan agreement. So what you had was a loan which was supported by a swaps arrangement, which was provided as a hedge. And there was an obligation in the loan agreement to maintain the hedge. So the loan couldn't have worked without the swaps. And you can see that from the case itself. It might be better for me to wait until my learned friend makes his point on this and then respond to it. But I think the short point that I'm making is that that was an agreement. You can see it from paragraphs 340 and 343 of that judgment, that the sort of connection that's required to say one agreement falls with the other is that there needs to be an interrelationship of that sort. The other point there is that it matters who is requiring the first agreement and who is the innocent party in this sense. So take the position, if I'm a bank and I'm induced to enter into one contract by, say, a misrepresentation, it was misrep in MAN, and if it's clear I wouldn't have entered into the second contract without the first contract, then you can see why rescission of one contract might lead to rescission of the other, because ultimately I've been misled into entering into contract A, and therefore misled into entering into contract B as well, because it's conditional on contract A. But that is not this case. The allegation here is that it is the bank which is the guilty party that made the misrep, that applied the illegitimate pressure to enter into the security agreement. And the defendant's case is that they would have entered into the facility agreement in the absence of that. So this case is very, very far from the situation that you have in a case like MAN, where you've got two integrally related agreements insisted upon by a bank, but where the bank is in a position to upset one of those agreements, and that carries with it the other. So that's the third reason why the duress argument cannot work. But I mean, your lordship only really has to be satisfied on one aspect of that, and clearly the clearest one is the question of whether it could be said to be unlawful not to provide finance in circumstances where the parties have agreed that there's no commitment to provide finance. That's all I had to say about duress. You've seen that the other way that it is put is that the guarantee, the so-called guarantee of working capital, created a collateral contract or an implied term in the facility. Your lordships, I'm sure, are aware of the guidance on the circumstances in which it's likely to find that there's a collateral contract concluded, and in particular the guidance in the case of intrapreneur. I just draw your attention to 2 points in that, if I may. You'll find that in Bundle E, tab 40. And if we go down to paragraph 9, it's page 1859 of the bundle. Sorry, paragraph 10. And the relevant legal principles are set out there by Mr. Justice Lightman, as it was. And it's probably worth you just reading paragraph 10, just to remind yourself if you haven't seen it lately.
Yeah.
So it's not just a question of were these things said, but it's also a question of whether they're intended to have contractual effect. And in the particular bit I wanted to draw your attention to was the third provision there, which is that if further negotiations and a written contract follow the statement and they don't include the alleged term, the assumption is that the parties only intended the written terms to be binding. So the difficulty for the defendant's case here is not only is there a facility which says nothing about this, there's also, as I've shown you, the draft side agreements from both sides, and the written documentation recording what was agreed, which says nothing about this. And so the question of whether there was that intention would be objectively determined by reference to what was said at the meeting. And we say it's just fanciful to suggest that there will be a finding that there was a further collateral agreement which was not referred to anywhere in writing, despite everything else being referred to in writing. And that's when you consider not just that particular point, but also the context. These are bankers. Both sides have engaged in banking before. There's a bridge financing between these two parties. They both know you need an application. They both know there's a credit approval process. Mr. Al-Mahari says, oh, well, I'm not a banker. This is hardly a matter of banking expertise. It's not about his subjective understanding of what was said. It's about whether or not the statements made at that meeting conveyed objectively the intention to enter into a contract. It's just not realistic to suggest that. And the other problem on that front is the point that I alluded to at the beginning, which is what would be the terms? What would be the period? What would be the rate? And importantly, what would be the security? We are just in agreement to agree territory. If Noor Bank said, yes, I will give you 100 million dirhams in working capital, but you need to find me 200 million dirhams worth of security, how is the bank to judge whether that is reasonable? What if they want 50 million dirhams worth of security? There's no objective yardstick by which the court could say these terms for working capital should have been agreed. So the result of that is the court just doesn't go down that line. It doesn't start the process of determining what should or shouldn't be agreed. As I mentioned, it's not said that there was an agreed syndicate facility, sorry, there was an agreed working capital facility which could just be drawn down, that was created at that meeting. So there had to be an agreement. So the best you can hope for arising out of it was that there was an intention to say, we will enter into an agreement with you by which we will agree to provide you with working capital. So it just doesn't get going on a contractual analysis at all. And then the attempt to draw this into the facility, there's just no basis at all for saying that this became part of the facility agreement. That's an allegation that's made by reference to an assertion of an implied term, but it's just assertion. And there's no reference to the usual authorities. We imply terms where that's necessary to give business efficacy, to make the contract functional on a business basis. And where you have detailed written contracts, the approach to that sort of thing is much more strict. And where you have a lending facility that's intended to be traded, then the authorities suggest that you're stricter still because you need the certainty to be able to attract secondary market. In reality, what's being alleged is not an implied term. It's a whole other separate line of lending, which the finance documents don't provide for. So where does the contract case get the defendants? Unless you're against me on agency, it gets them a collateral agreement with Bank to provide, to agree to a working capital facility, which on the evidence was never called on, which on the evidence was never asked for, as far as we can see. Well, sorry, I qualify that. There are some assertions by the chairman that he said in meetings, "Where's my working capital?" But there's no documentation to support that. But even if there was an implied term in the facility to perform the collateral contract, so the high point of my learned friend's case, Noor's breach doesn't, and even if you find Noor at trial, Noor was in breach of that, that would not amount to a defence. My learned friend refers to the prevention principle. So that is, if you cause my breach of contract, you can't rely on it. And so then they say that a breach by Noor would be a defence in not providing financing, would be a defence to all the lender's claims. No authority is cited for that, and the submission is wrong. Why is it wrong? Because it's provided for in the contract itself. If we look at Bundle B, page 916, we're looking at the Common Terms Agreement. And it's really clause 2.2.1. So even if this collateral contract gave rise to some obligation under the facilities by Noor to provide further finance, that is not something that can be blamed on the other contracting parties. There's several obligations. And so when it comes to default, the group can't say, well, Noor didn't provide us with working capital, so we don't have to comply with these obligations. It's not a breach by Emirates Nbd, for example. So Emirates Nbd is perfectly entitled, even on the high point of my learned friend's case, to say, all right, I want my money. You haven't provided me with my money. Here's a notice of default, accelerate the loan, debt's due. That's the end of it. So for those reasons, we say the contract claim simply cannot work. And then finally, we get to the misrepresentation claim, which is the last bastion of the defaulting debtor. Now, in terms of the facility itself, could a misrepresentation affect the facility itself and give rise to a right to set it aside? We say there's no prospect of success on that. Even if you attribute even if you are not with me on the agency point, because as I've shown you, they had on their own case no choice but to agree to the facility. That's the thrust of their case. We had to agree to this facility. That's why we gave the security. Had we not had all of these threats, we would have just entered into a facility on similar terms. It was the OBN security that was the problem. So the misrepresentation could not be said to be relied on to enter into the facility. It could only be said to be relied on to enter into the security arrangements. There's no case that but for the representation, they would not have agreed the facility. So in effect, it comes down to a claim for misrepresentation based on the allegation that Noor said, we guarantee to provide working capital. But they say, well, they had no reasonable grounds for saying that. Now, your lordship made the point in the outset, how does this work? And we'll hear from my learned friend. I just make the point that there's a difference between saying this will happen and on the other hand saying I will do X. There's a fundamental difference, and the one tends to attract or can attract implied representations of reasonable grounds and so forth. But if it's the sort of statement that is being asserted, then it's a warranty. It's a contractual promise. It's an undertaking. It's however you want to call it. It's a contractual promise that's being asserted. Not every contract brings with it an assertion that there are reasonable grounds to say that you will comply. But in any event,
well, you can misrepresent your own state of mind. I intend to do something, and if you don't have that intention, then that's a misrepresentation of state of mind.
yes.
But if you say I guarantee to do something, it seems to be it's plainly a promise.
Yes. So
I mean,
that's that. So that's right.
So.
And then the second point is that even if it could go beyond that, it comes down to it may come down to a question of reasonable reliance. So say you could characterize it as a representation. Even if you get over the improbability of the problem of these statements being made, it is far too vague to stand as an actionable representation because there are no terms. So you can't reasonably rely on a statement of that sort about a working capital facility when the terms are totally unknown. To say security being the central point. So we say we do say there are no real prospects on the factual issue, but even if you find that there are prospects, what it gets you to is a totally fanciful counterclaim against Noor by the first defendant in negligent misstatement, effectively, or misrepresentation under the Misrep Act. And that's a promise which is too vague to be enforceable as a contract, but nevertheless they have to say is sufficiently certain to be reasonably relied on to enter into a facility of 1.75 billion dirhams and sign away what is said to be the group's only unsecured collateral. Now, if you were minded to let that claim continue, it would be a claim. It would not be a defence. So it would be a separate standalone claim advanced by the group against Noor Bank. Not be a defence, it would not be a ground to stay execution. And we would in due course say it should only be allowed to proceed on conditions, amongst them security for costs and the like. But that's another day. But we do say that you can decide today, and the application is today, that you should decide that counterclaim has no real prospects of success. That's all I was going to say about those aspects of the counterclaim and the defence. I was going to come on to this question of Sharia, and then I was going to make a couple of points in response to the complaints about the joinder application. The application has been made, but as you know, the purpose of the joinder application was to put the case that the rights and interests of Noor have been transferred to Dubai Islamic Bank. So I'll just say a few words about that at the end. But the Sharia one is the main issue.
Why would the last point matter at all? It's only a question of which party would obtain judgment, isn't it?
On my case, yes. On their case, it might be said there is a defence as a result of the counterclaim. There could be a set-off. It might be said there could be a set-off. And if there was a set-off, it would matter how many assets there are in Noor Bank. And the result is, at the moment, I think the answer is there aren't any assets in Noor Bank because Noor Bank is mothballed. because its business operations have been taken over by DIB.
Yeah,
So it might make a difference, but it wouldn't stop there being a judgment. It would just be whose judgment is in favour. But if you're with me on the no set off, it doesn't make a difference. What they're left with is a claim against Noor Bank, not against DIB.
Yeah.
So just dealing with the Sharia bit, this is only directed to the Islamic lending. As I've said, that makes up approximately 750 million dirham of the lending. So that's about 500 million from Noor and about 250 million from the Commercial Bank of Dubai. The rest of it was conventional lending. And the way that the argument works, as we understand it, is this. And I'll show you this in due course. First, it said the Murabha had to comply with Sharia on its terms. Second, although no Sharia standards are specified, the agreement should be construed as incorporating a particular set of standards, the AOFI. I'm going to call them the AOFI standards. Third, it said the arrangements in the financing in the Master Murabha agreement breached those standards. And fourth, it said the effect of that is to render the Master Murabha agreement a nullity. That's how it's pleaded. And we say that it's just misconceived. Now, the first point that is made against me, paragraph 203 of my learned friend's skeleton argument, is that it's just not open to me to make these points because there's a registrar's direction which is recited in my learned friend's skeleton, which says expert evidence of Sharia law in the DIFC courts shall be established as a matter. These are to be established as a matter of expert evidence. Now, we say that is wrong. You can deal with this. And the way I put it is like this. First, there is a Court of Appeal decision, which my learned friend refers to, Fidel and Felecia, which actually I was in, where the Court of Appeal determined that it is up to the trial judge to decide how they approach issues of non-DIFC law. They will normally adopt what is called the arbitration approach, which is on, as Chief Justice Wang understood it, was simply that you ordinarily would just have submission. It's an international court, you just do it on submission. However, there is discretion for the trial judge to say, I need some assistance, and make an order for experts to be provided. So, to the extent that the registrar's direction is inconsistent with that, it can't override the effect of a Court of Appeal decision decided as long ago as you see as 2015. Actually, I think it was 2016, which is based on the Court of Appeal's interpretation of the court law. And the court law says that the court can do anything it likes in terms of evidence. So that's the first point. It's at best guidance. You cannot have your hands tied, I'm afraid, by the registrar. You'll be happy to know. The second point is the court, we say, obviously needs to apply a degree of common sense, even though it's going to follow these requirements. So it can't stop the court from inspecting the allegation and deciding whether there's anything in it in the round. Just because you say the word Sharia doesn't mean that we have to have a trial on expert evidence. So those are the sort of, if I can put it like this, DIFC procedural points. The third point is that actually what we are doing here is interpreting and construing an English law contract. So the pleadings, the way the pleading works is actually to seek to incorporate the principles of the AOFI Sharia guidelines into the contract. I better show you how this all works in the pleading, and then you can see how it's put in the skeleton. If we go to page 46 of the defense of the bundle, page 46 of the bundle, And it's the bottom of that page, paragraph 94. So the first pleading is referring to the banking law issued. So it says the higher Sharia authority of the central bank sets the standards and so forth, pursuant to Article 17 of the banking law, issued a standard requiring with effect from 1st of September 2018 all Islamic banks, Islamic windows of conventional banks and finance companies offering Sharia compliant products and services in the UAE to comply with the standards set by the AAFE, a Bahrain based standard setting body, when assessing whether a financial transaction was Sharia compliant or not. That assertion is inaccurate, and I'll take you to that. As I say, it was introduced in the 1st of September, but there was a grace period during which banks were required to, if I can put it like this, bring their products up to standard. But I'll show you that in due course. The pleading then carries on, paragraphs 95 to 97. So it pleads out what is in fact a recital of the master murabha under the Islamic finance facility. You see there, the investment agent will purchase commodities and sell them to the purchaser, and then all in accordance with the Sharia. Pleads out the way in which Sharia is defined, and you will see that it is not defined specifically by reference to AOFI. And we'll go back through that in a moment. I'm just showing you the pleading. And then 97, in the premises, the AOFI standards are incorporated by reference into the master murabha. So that's the way it's put. They then plead out the standards. We don't need to look at those in detail yet. And then down to 103, they plead that the provisions of the murabha are contrary to the standards. And then they plead out why. And then in 107, they say, in the premises owing to the above violations, the purported master murabha is inconsistent with a valid murabha agreement, and as such, it and the purported Islamic facility are a nullity. So it is ultimately a question of the content. Well, there's a prior question, if I can put it like that. Before you get into the standards, there's a prior question of English law, which is a pure question of construction of the contract about whether or not the AOFI standards are incorporated into the contract. And then I'll come on to that. And then the fourth point is actually when we get to the complaints about breach of the standards, we're not really arguing about what the standards mean. We can take the standards at face value. What we're arguing about is the meaning of the contract and whether it fits within the conduct which is described by the standards. Because those standards are said to have been incorporated, you can construe them like any other instrument. And so that's really where the argument lies. So there are three, essentially, just to give you a preview, and I'll go through them in a moment, but the breaches that are asserted are these, effectively. One, it is said, nor should not have acted as an agent for itself. There's a standard which says you shouldn't do that. And the answer to that is it didn't, as a matter of the functioning of the agreements which you can construe. The second one is nor cannot lend under a murabha to a conventional bank when it knows that that bank is going to use the money for non-Sharia lending. It didn't. And the third standard says the murabha has to set the profit and the fees at the outset. They can't be variable during the course of the murabha. Answer is it does. They're not variable. So those are really about construing the underlying agreement, not about saying what are the Sharia standards. We accept that those are the ones that apply. So let me take you through this case just a little bit more detail by reference to the documents themselves in the murabha agreement. If we start, please, at page 750, which is in bundle B, you'll see the master murabha agreement itself. 748, sorry, is where it starts. And then 750 is the recital that is referred to and relied on. So this is the kind of core of the argument, at least as pleaded. And it's recital C. So it's not a term of the agreement. And what it says is recital C, as you've seen, under the Islamic facility, the investment agent will do certain things, purchase commodities and so forth, all in accordance with the Sharia. But note also there's another recital, recital D. Each party has independently reviewed the Islamic finance documents for the purpose of ensuring their compliance with the Sharia and is satisfied that they do so comply. So all the preamble is doing is saying that the parties agree that the arrangements which follow are consistent with Sharia. It's not saying that those, any particular standards, but in any standards at all, are incorporated into the contract. These are not even terms. So they don't impose obligations. They don't specify any contractual results. So the first point is that nothing is incorporated and the argument doesn't get off the ground. Now the response to this in the skeleton argument is worth looking at with a degree of care, because it does not recite the case law accurately on which it relies. It's paragraph 218 at page 77. This is a question of English contract law. What is incorporated by these words? And what my learned friends say, paragraph 218, they say, where a contract states that it is governed by or operates in accordance to a set of regulatory rules, this may, on a proper construction of the contract's wider terms, constitute an express incorporation of such regulatory rules. In fact, that is not at all what the case that they rely on says. Target Rich International, yes, says, and I'll show you it in a moment, if the contract says it is subject to or governed by, that may incorporate the rules. But it says just a mere reference to rules is not going to be sufficient. And the cases at bundle F, I think, page 7, tab 77. It's a decision of Adrian Beltrami, QC, sitting as a High Court judge. We only need to look at 2 paragraphs, which you'll find at page 3948. And so he draws a distinction between 2 different types of case, which is elided in my learned friend's submission. So if you have 3948, paragraph 94, it says there are some cases in which a background set of rules have been held to be incorporated into an agreement by the use of express words. Mr. Justice Thomas held that a document which stated that the transactions would be governed by a code of conduct established by the Bank of England achieved the incorporation of that code, and then refers to another case, an agreement which was said to have been subject to regulatory rules. And then this is the critical bit, which is just overridden by the statement in the learned friend skeleton. In a number of other cases, including several of those which I have summarised above, attempts have been made to argue a case of express incorporation, normally of the Cobb's rules on a more general basis. In broad terms, claimants have sought to fuse the existence of regulatory obligations with contractual rights agreed between the parties by drawing attention to instances where regulatory rules were mentioned or even described within a set of contractual terms. Such attempts have been uniformly unsuccessful. Whilst the court will give effect to clear expressions of incorporation, the cases demonstrate a consistent recognition that regulatory obligations are distinct from contractual rights. They may operate in parallel without fusion, and in particular, mere references in contractual terms to the existence and content of regulatory obligations will not, or at least will not likely, be treated as an incorporation of any specific obligation mentioned, let alone of the rules as a whole. So the submission that a contract which states that it is in accordance with a set of regulatory rules is not, may constitute an express incorporation of those rules, is not what this case is saying at all. And here in this recital, as we just saw, All that is said is that under the Islamic facility, the investment agent will purchase and sell all in accordance with the Sharia, and each party has independently reviewed the Islamic finance documents for the purpose of ensuring their compliance with the Sharia and is satisfied that they do so comply. There's no express incorporation, so the starting point of the case simply falls away. The second point is that there is no reference to any particular standards on which were incorporated. If you see this as some attempt to incorporate, the only reference in the recital is to the Sharia, and there's actually a definition at page 754 which just says Sharia means the rules, principles, and parameters of Islamic law. So my learned friend has to say that you have to construe the Sharia as incorporating standards, but that by incorporating those standards, the effect of the agreement is that it is void. And you just have to state it to realize how utterly uncommercial that submission is. Parties intend binding agreements. The third point is that the banks were not bound to ensure, as at 27th of December 2018, that their products were consistent with the AOFI rules at all at that time. Now, the defendants say in their skeleton argument that that is a deeply worrying submission. We don't say we're not bound to comply, or those banks in the syndicate who are Islamic lenders are not bound to comply now with the AOFI rules. But there was a grace period in the resolution. This is not a question of Sharia, it's just an interpretation of the requirements to comply with Sharia. So this resolution you will find at bundle F, tab 87. The banking law appears at tab 86, and then tab 87 is the resolution itself, which is relied on. It starts at page 4206. You'll see it's dated at the top, 4th of July 2018. And paragraph 1 resolves the Sharia standards issued by the accounting and the AOFI standards shall be binding on the internal Sharia control committees of the financial institutions that preform all or part of their activities in accordance with Islamic Sharia rules from 1/9/2018 onwards. So it operates on the Islamic Sharia, the Islamic internal Sharia control committees who authorize products. That's how it operates. And then you'll see paragraph 2 makes this abundantly clear. The products, activities, and services adopted and currently used by IFIs prior to this resolution should be revised in accordance with the AOFI Sharia standards based on a time plan that should not exceed by 31 December 2020. So the result of the introduction of this standard is that A, the internal Sharia control committees, when considering whether to issue a fatwa authorizing a particular product, are now bound immediately, from the 1st of September, to apply those particular standards, number one. Number two, that existing products, which all will have previously been authorized by those standing committees, need to be brought into line with the resolutions on a time plan that should not exceed by the end of 2020. So there is a grace period for existing offerings. And if you see at paragraph 3, the banks had to explain how they were going to implement that change by the end of the year, 31st of December 2018. So my learned friend presents this in a skeleton argument as some sort of rigid regulatory mandatory regime. He doesn't quite go so far as to assert that the banks are in breach of their regulatory obligations by entering into these Murabha agreements on the 27th of December. But there's no sense in which it could have been a breach of these obligations in December 2018 to enter into an agreement which was not consistent with the earthly standards. And the way in which this document, the resolution, deals with that transition makes it absolutely clear that it's not going, any breach of the standards before the end of 2020 isn't even going to be a breach of any kind of regulation, let alone anything that would render the whole thing void. That's before you get to any questions about Sharia. The next point, the fourth point on this front, again, before we get to Sharia, is the question of waiver and estoppel. So this is an English law contract, and I think your lordship's seen them. I can take you to them just for good measure if you like. But there are various clauses in which the parties say they waive and will not take a point on Sharia. My learned friend's position has to be, can't be held to that. I'll show you them very briefly if I may. It's bundle B again, page 768. Clause 13. Waiver of defences. The purchaser waives any defence he might otherwise have in any jurisdiction which are based on the non-compliance of the Islamic finance documents with the Sharia. This waiver applies irrespective of any law or any provision of the Islamic finance document to the contrary. That's the Murabha, Master Murabha, and then for good measure, you've got the Common Terms Agreement at page 933. And it's clause 17, representations and warranties. And if we go down to warranty number 27, which is on page 939, at the top of that page, 17.27.2, the parties represent and warrant that they do not have any objections, nor will it raise any objections as to matters of Sharia compliance in respect of or otherwise in relation to any of the provisions of the Islamic finance documents. Now, in relation to this, my learned friend says in his skeleton argument, paragraph 230, and this is said for the first time, that the claimants are not entitled to rely on these clauses. Why? Well, firstly, they say estoppel does not work if it's contrary to public policy. So now the defendants have to say not only that the provision of the Murabha agreements are contrary to public policy, but that these agreements not to raise any points about Sharia are contrary to public policy. And they rely in particular on the case of Parmar, and no doubt you'll be taken to it, but when you are, you will note that that is a case where there was an express prohibition in English law in the Cobbs regulation to the effect that you cannot exclude or restrict a duty by a communication. And so the question was, could the bank rely on a disclaimer that excluded or restricted the duty? And the law said, no, you can't. So much so obvious. If the law says you can't do it, the applicable law says you can't do it, then you can't do it. But there's no suggestion of a law of that sort. There's no suggestion that it's contrary to the UAE's regulatory regime for the bank to have a contractual provision preventing a party from disputing Sharia compliance. There's various other points made. I mean, there's a reference even to Dicey that English law, the courts will not enforce a contract to further an adventure to break the laws of a foreign state. I mean, that's a pretty extreme submission that these sorts of agreements would have any sort of effect. And there's no support for it. Fundamentally, ultimately, as I pointed out, there could be no breach of regulation in circumstances of the resolution that I've taken you to. But even if there was, there's no case really about how that couldn't be the right to rely on it could be excluded by 1727 and the other provisions I've shown you. And then we get to the bit that my learned friend says I'm not allowed to talk about, which is, or you're not allowed to decide, which is the question of whether there is realistically any breach of the standards. And I can show you quite quickly why we say that that's just baseless. So doing this as fast as I can, and I don't think this will take me more than 15 minutes, so I should be finishing on time. We need to do it by reference to the my bundle of authorities. You will find there behind E, tab 25, AOFI standard number 23. And that is the first complaint. And if you go down to page 1526, the standard relied on is paragraph 6-1-2. And the requirement is an agent should not conduct deals with his own self or with his son or daughter who is still under his guardianship, or with his partner in the same contract. And then 613, the agent should not act for both parties to the contract. And there is commentary attached to these standards. So these are in the standards themselves. 1535.
I'm sorry. Wait a moment.
Of course.
I haven't got the right provision.
So it's 1526, 1526, and its provision is 6-1-2. We at this point we're within standard 23, and there's a series of provisions. 6-1-2, an agent should not conduct deals with his own self, and 6-1-3, the agent should not act for both parties to the contract.
Got it.
And what's said is, well, Noor was both the arranging agent, or and acted as in various agency capacities, and also a provider of finance, and therefore that is them acting as agent for themselves. But if we look at the commentary at 1535, we see what this is intended to deal with. This is part of the standards. It's the final bullet on 1535. Impermissibility for the agent to represent both parties to the contract. As per the Hanafi school, and the predominant view in the Shafi school, is to avoid assigning both offer and acceptance to the same party, and hence prevent any probable self-bias. Adopting the viewpoint of these two schools is therefore most suitable for the institutions to avoid malpractices and misleading formulas in making transactions and prevent overlapping guarantees.
I'm so sorry. Could I ask what page you're on there?
Sorry, yeah, it's 1535. So, as you know, a murabha contract takes the form of a sale contract with a deferred price. And so the point is simply an agent should not be on both sides of that contract, as principal or as agent, and it is not. And B, the other answer is, Noor is not acting as an agent for itself on the true construction. It's a principle of English law that the party can't contract with itself, can't act as agent for itself. So that the true construction of what's going on in the syndication is that it is acting both as principal, as a lender, but also as an agent in other capacities. So if you apply the standard, you mustn't be on both sides of the deal. You mustn't act when you're dealing with a murabha agreement as both agent and principal. Then it just doesn't make any sense. Not by reference to an interpretation of the standard, but by reference to understanding what's going on in the transaction. That's the first point that is asserted. The second point that is asserted is that the defendants rely on standard number 30, which is behind tab 26 of the same bundle. which is under the heading monetization tawarruk. And the standard is at paragraph 3-2, which you will find at page 1543. (3-2) says the institution, that's the Sharia lending institution, the bank, should not perform monetization for the benefit of conventional banks when it discovers that such banks are going to use the liquidity for interest-based lending instead of Sharia-compliant operations. Right, what does monetization mean? Monetization is defined at paragraph 2. Monetization refers to the process of purchasing a commodity for a deferred price determined through muzawama, bargaining, or murabha, markup sale, and selling it to a third party for a spot price, so as to obtain cash. So that purchasing and selling should not be performed for the benefit of conventional banks if it is known that they're going to use that money for interest-based lending. Now, that is not what is complained of here. What is complained of is that the money, because it was a refinancing, was going to be given to the group and then applied to repay conventional loans. That's not prohibited by this standard. The standard, I mean, you'd have to interpret the standard as saying there's got to be two totally independent economies. One is Sharia compliant and one is not. But that's not what the standard says. It just says you cannot buy and sell for a conventional bank. So they can't lend to a conventional bank. And one can see why you need that. Because, for example, what a Sharia bank could do is use their Sharia window, set up a bank, a company in the DIFC, lend to that company, and then use that money to spread it into the conventional market. And so he's saying if you want to be a Sharia bank, you can't do something like that. But it's about lending to banks through the use of murabhas, not lending to parties like the group. That's the second allegation. And then the third allegation relies on Sharia Standard 8, which you'll find behind tab 24 at 1477. But the particular provisions relied on are at page 1493. And they are 4.6 and 4.7. I don't think we need to read all of them, but just to give you a flavour of it. 4.6, it is an obligation that both the price of the item, that's the goods being sold under the murabha, and the institution's profit on the murabha be fixed and known to both parties on the signature of the contract of sale. And then it says it's not permitted under any circumstances to subject the determination of the price or the profit to unknown variations. For example, you can't set it by reference to whatever Libor may be in the future. 4.7, sorry.
I've lost the reference, I'm afraid.
It's 1493.
1493, sorry. Yeah.
So it's 4.6, it's an obligation that both the price of the item and the institution's profit on the murabha transaction be fixed and known to both parties on the signature of the contract of sale. So that's the time when it needs to be fixed. And then it's not permitted to have it be variable, for example, by reference to Libor. So you cannot agree a murabha agreement with a deferred profit with a deferred price that's due in, say, 3 years' time, and in the intervening period, the rate of profit needs to be determined by reference to something that isn't known at the original date. And similarly, 4.7, the institution's profit markup in murabha must be known. And the mention of the total selling price is not sufficient. It's permissible that profit be determined based on a lump sum amount for a certain percentage of the cost price only, or for the cost price plus the expenses. So what the complaint is here is that there are provisions in the master murabha which set the profit by reference to, for example, EBOR plus a margin. But that is just simply not a misunderstanding of the standard, it's a misunderstanding of the Master Murabha agreement and how it operates. Because the Master Murabha is not a contract of sale, it's not a Murabha contract. It sets the terms on which Murabha contracts will be concluded. It's a framework agreement. So, and this is hopefully the last bit of this. If we go to the actual Master Murabha, you'll find it at page 748. The mechanism is at page 757.
Which bundle are we talking about?
B. Yeah, back in B. 757. Do you see that? Clause 5, transaction requests. So this is how individual Murabha contracts will be created. 511, the purchaser, that's the borrower, has to deliver a transaction request. It's an irrevocable request. 515, last sentence. The parties acknowledge that the purchaser's irrevocable undertaking to purchase commodities shall, for the purposes of Sharia, constitute a promise to purchase by the purchaser. And then 5.3, offer letter. At any time after there is that request, but no later than 11 AM on the same date, the investment agent shall offer to sell the commodities to the purchaser by sending an offer letter specifying the terms of sale. And the offer letter has to set out the transaction date, the quantity and type of commodities, the cost price, and then also the Murabha profit and the ancillary cost and deferred sale price, which the deferred sale price is a combination of simply the cost price and the profit, and therefore the net amount. So it all needs to be set out. And then 541, acceptance. The original acceptance, this is the third line, must be delivered to the investment agent, but the Murabha contract will have been concluded on receipt of a copy of the signed acceptance by the investment agent. So that's when the Murabha is concluded. In other words, after the offer letter's gone out with all of those details in it. 542, again, when the purchaser issues the acceptance, a Murabha contract shall be concluded, and that's when ownership passes. And if you go up to 753, you see how the Murabha profit is calculated in any particular offer letter. So see, Murabha profit is defined at the bottom. Cost price, the profit is equal in MP is A times B, where A is the cost price and B is the aggregate of 1 EBOR on the quotation day plus the margin, which by the way is 3.5%. I don't need to show you that, that's in the common terms agreement. And then what happens, and then attached to this document, this Murabha master agreement is a form of offer, and you can see it at page 772, which is the offer letter, and then a form of acceptance. So that is the Murabha transaction. And then we also have the actual transaction requests that were undertaken. So if you look at page 1073, so that is the actual transaction request, the original one, in January 2019. And it says, number 1, you have 1073, paragraph 1, the purchaser wishes to enter into a Murabha contract as follows, and sets out the cost price. And then you have the offer letter at 1079, which sets out the terms. Now, as at that date, 1079, 21st of January 2019, you have all of the terms are fixed. Murabha profits fixed, deferred sale price is fixed, deferred payment date is fixed. And you'll see it rolls for 3 months, takes you to April, and then it just happens again. Paragraph 1082, you've got another request. So page 1082, another request. Page 1084, another offer. That is then accepted on the following page. And again, the offer sets out precise terms to the penny, to the piece, the profit. And then there's another one in July at 1087, and that's the final one that there was, which is the transaction request, and then 1089 the offer letter, and then 1091 is the 1090 is the acceptance. So those are the Murabba agreements. The complaint is there's a variable profit in the master Murabba. And in one sense, that's right, in that when you get to each Murabba agreement, you then at that moment have to determine what the interest rate is, and therefore what the profit will be for that Murabba contract. But the master Murabba isn't a Murabba. So there's no real issue here with Sharia compliance. It's all just noise. But even if there was, there wouldn't be a basis for saying that it made the contracts void. And even actually in the skeleton, the paragraph 227(1, the defendants don't positively assert that the effect of a breach of Sharia would be that the contract, or the AOFI standards, would be that the contract would be void under Sharia law. They just say the court can't decide that today because it hasn't got expert evidence on the issue. Well, it's irrelevant, we say, because the question is one of English law of the contract. They also say, generally, that the court cannot rule, this is paragraph 227(2) of their skeleton, they say the court can't rule on what English law requires in this contract without knowing what Sharia says. I think that must be the incorporation argument. But again, no argument is developed as to why English law would require the contract to be a nullity. And then at 223, subparagraph 4, which is on page 80 of their skeleton argument. It's difficult to know precisely what they're saying here, but they say, firstly, they say in the middle of the paragraph, as set out in relation to ground 13 above, the claimants were required under the 2018 banking law to comply with the AOFI resolution. Well, maybe, but the AOFI resolution doesn't require compliance with the standards yet. But anyway, get over that. Whether or not that obligation is enforceable under UA regulatory law by way of private action is neither here nor there. And then they say slightly differently, the point still remains that as a matter of regulations to which Norbank and CBD were subject, it was unlawful and contrary to the Sharia to fail to adhere to AOFI standards. Now, I've shown you the pleadings. That is not how the case is pleaded. And even now, it is not obviously being said that the banks were in breach of their regulatory obligations in such a way as to render these agreements void. But even if that was the case, and if it was the case, it would be my learned friend's rather hoisted by his petard because he needs to apply to amend, and on his position, the court then needs to take a view on whether that amendment has real prospects of success, which on his view, the court can't do without getting expert evidence of Sharia law. But in any event, I've shown you can engage, at least to the extent that I've described, with these questions in this rather broad way and see that there was no breach. But even if there was, there was just no obligation under the contract to comply, or indeed regulatory obligation to comply with the AOFI standards at that time. And then there's really just an assertion that there would be a breach of public policy in enforcing the estoppel and waiver points. So for those reasons, we say there's just no real prospect on the Sharia points. And then that just leaves the question of joinder. I've heard what your lordship says about joinder. Does it matter? It could. And more important, from the claimant's perspective, as between Noor and the IB, they obviously want the judgment in favour of the correct party, but in any event, I think the point that's taken at the moment is simply that they say that Noor and Dubai Islamic Bank should be put to proof that the transfer was Sharia compliant, or that it was that it was approved by an internal committee. That's effectively what they say. It's not a positive defence. They don't even say it wasn't, or that there are specific aspects of the transfer which might not have passed muster with a committee. And so the question is, can you just show up to court and say, for example, prove that this contract that I entered into with you complied with regulations without actually exerting a positive case in relation to that? Is that sufficient to get over the real prospect of success? It's not a defence, we say. So there's nothing you need. This was obviously raised very recently, and the result of that is that I don't today have evidence before you of precisely what was or wasn't done in terms of committees. But I just meet this by saying it's just not sufficient to turn up to court and say, well, prove that one aspect of the regulatory requirements are complied with. It's not a positive defence. And then if your lordship gets to the point where you accept that there is no defence as a result of any of these counterclaims, even if you get that far, and I say you get that far just on the agency point alone, plus the no set-off clause, then it just doesn't make any difference which party is awarded the money, and we can live with the judgment in favour of either of those two parties, I think. And that's it. There's no more to it than that. So we ask your lordship to see this defence for what it really is. It's an attempt to make this all look terribly complicated and put off the evil day, when in fact it is a straightforward debt claim faced with just a raft of unrealistic and fanciful points. Well, those were my submissions. So unless there's anything I can help you with at this stage, I was going to stop there.
No, nothing at this stage. Thank you very much.
Thank you.
Mr. Fraser, what do you want to do?
Well, we could have the short adjournment now, if you like, or I could speak for an hour and then we'd have the short adjournment. But I think we probably have got, am I right in thinking we've got until 2 more hours of court time? So it might be sensible to have the short adjournment now and then pick up at 1 p.m. British time, or just do all the 2 hours straight through, as your lordship wishes.
It's what, it's 3 o'clock in Dubai, is it?
Yes.
I'm thinking of, we gave quarter of an hour break at whatever time it was.
Yeah.
But they haven't had much opportunity to feed and water, so to speak.
Yes.
I'm inclined, I think, probably to take half an hour now, if that makes sense.
Yes.
Which would enable you to have a sandwich, if nothing else, I suppose.
You're grateful.
And then bat on from about past.
Yeah.
For whatever seems an appropriate length of time, really.
An hour and a half after that.
Something of that kind.
Yeah.
Yeah,
Okay.
does that make sense?
Makes absolute sense. We'll resume tomorrow.
2.5 hours, wouldn't it? It would be 2.5 hours, would it not? We've got until 3 today, I think.
Well, as your lordship wishes. If we've got more time tomorrow, then we're in your lordship's hands.
I'm really thinking more in terms of how things are working in Dubai. Mate, are you there somewhere?
Yes.
From your perspective, what makes sense?
So we can, given that it's Ramadan timing, so the registry will be available until 5 p.m. today.
Yes.
Yeah, so that's still 2 p.m. British time.
Well, let's take half an hour now then, and then start again at past or thereabouts.
Hello.
Very
All
good,
right.
thank you.
Thank you. Yes, Mr. Fraser, ready when you are.
May it please your lordship. Now, it won't come as any surprise that my clients don't see it quite the same way as my learned friend's eloquent speech on behalf of the claimants. What we submit is that my learned friends' clients, they're requiring your lordship to endure a misconceived attempt to shortcut the normal trial process. If you step back, this is a 1.8 billion dirham case bristling with complicated factual and legal points, which after lengthy disclosure and witness proofing exercise would rightly normally require a substantial trial to get to the bottom of. Now, the claimant's attempt to cut all this short by getting judgment from a brief immediate judgment exercise, which is itself designed to address short and simple points of law or fact, is plainly, we say, an abuse of the court's process. And so much so, we say, that it strongly suggests that the claimants are willing to take the risk of failure today to see if they can get lucky in front of your lordship and thereby avoid giving disclosure and avoid having their witnesses cross-examined in due course of trial, which is exactly why this exercise, we say, should not be allowed to succeed. Now, in summary, we're in exactly the territory of three rivers here. Your lordship should be astute to avoid falling into temptation which Justice Clark fell into in the first instance in that case. He thought he could save everyone time by coming to a swift determination of what he thought was plain and obvious, only to run into the law lords, who made it very plain that even in a case where the ultimate answer looked clear, you should desist from granting summary judgment if you had to go through a mini trial to get there, because you could never conduct a mini trial fairly in this sort of summary procedure, and thus effectively you would not be doing justice if you chose that route. Just by way of outline, the quote that I'd really like your lordship to bear in mind in this is at paragraph 69 of our skeleton. It's Lord Hope, well-known phrase, but I think quotation about why mini trials it's a paragraph 69. Lord Hope explains it's easier to conclude that simple cases are fanciful, since complex cases are unlikely to be capable of being resolved in that way without conducting a mini trial on the documents, without discovery, and without oral evidence. He goes on, the method by which issues of fact are tried in our courts is well settled. After the normal process of discovery and interrogatories have been completed, the parties are allowed to leave their evidence so the trial judge can determine where the truth lies in light of that evidence. There are some well-recognized exceptions, and he talks about if matters are clear as a matter of law, or if it may be possible to say with confidence before trial that the factual basis for the claim is fanciful because it is entirely without substance. And we're going to be able to say, could your lordship really say that our defences are entirely without substance? The simpler the case is, easier to take the view that something is called properly resorted to summary judgment. But more complex cases are unlikely to be capable of being resolved in that way without conducting a mini trial. And that's really what's happening, my lordship. And we say lordship should not embark on that procedure. Now, in terms of my structure, I'm going to obviously deal with the factual submissions first, like my learned friend did, and take your lordship through the documents and the passages that we like your lordship to bear in mind before coming to judgment today. And then I will address the numerous grounds for immediate judgment pursued by my learned friend. I should say, because of the sheer amount of material, I'm unlikely to cover orally every argument, but we do rely on our written submissions so far as I do. Now, factual submissions. In terms of the factual issues, your lordship be aware that on the pleadings, there were, emphasis on the were, two core issues of fact concerning the 16th of December meeting for a final court to determine. Namely, firstly, did Norbank threaten to pull the rug from the syndicated loan if BBIH did not give up the ABN as mortgage security? That's called a withdrawal threat. Secondly, did Norbank promise to supply a guaranteed 100 million dirhams to BBH Group if the ABN was given up as mortgage security? Now, the first issue has now gone, as the claimants now admit in their evidence for the first time after denying it in their pleadings that the withdrawal threat was indeed made. The second issue is very much alive, and your lordship has to decide whether the claimant's chairman's evidence that such a promise is made is fanciful or not. Now, there are two parts to this we suggest. We submit a key question for your lordship will be how likely it was that, contrary to the claims made otherwise by Mr. Ali in his witness statement, your lordship seen that this morning, that the subject of working capital was raised at the meeting. on the 16th of December. He says it wasn't even raised. You have to consider, the chairman says it was, if the chairman's evidence is regarded fanciful, entirely without substance, or is there something in it? I'll come on to significance in a minute, but to understand the question of whether it was likely to have been raised, your lordship needs to look carefully at the background to the meeting. If your lordship does do that, you will see that it doesn't just look likely the working capital was raised, it looks inevitable that the question of further working capital was raised and discussed at that meeting. In this respect, the documents and the evidence I'll show your lordship, all evidence that the raising of further working capital from the syndication was central to my client's intentions throughout 2018. It leads to the submission that it's not really likely that on the 16th of December, when the Nor Bank officials wanted to take away the OBN facility, that the chair would not raise the question of working capital in exchange. After all, that was his last material unencumbered hope of raising working capital from anyone. And without working capital, everyone knew the group was in trouble. And if your lordship then thinks that the subject of working capital was likely to have been raised, notwithstanding Mr. Ali's denials by the chairman on the 16th of December, then we say your lordship cannot then reject as fanciful the chairman's further evidence that the Nor Bank officials, including Mr. Ali, indeed made the key working capital promise at the meeting to get the deal over the line. That's to bear in mind. Now, turning to the factual background more specifically, we divide it into 3 periods leading up to the meeting in our skeleton. In paragraphs 12 to 16, we discuss the early period. That's 4 months between April 2018, August 2018, when working capital was envisaged by all parties to be part of the syndicate loan itself. Secondly, the period from August 2018 to just before the OBN meeting in December 2016, that's covered in paragraphs 17 to 40 of our skeleton, when the working capital was still understood to be important to the group, to the chairman's group, but the evidence suggests that it was going to be organised outside of the syndicate loan, possibly by Nor Bank itself. And thirdly, the third period, the OBN meeting itself, covered at skeleton paragraphs 40 to 52, where the accumulated evidence, we say, strongly suggests that such a disputed working capital promise was made, or at least your lordship cannot dispute the prospect as fanciful. Looking then at the first period, if I may, the working capital evidence and some other bits we rely on from this period include, beginning with the chairman's witness statement of paragraphs 21 to 23, which will be at bundle D 21. At page 1318 of the bundle, if you'll read paragraphs 21 and 20 to 23 to yourself,
Yeah.
you'll see there that the group was in financial trouble. The new CFO, Mr. Vig, comes up with a plan, the syndicated loan plan. It has 2 points to the plan, 22. One, by syndicating it, it would not have to deal with complexity of negotiating or renegotiating with various banks that they could leave with one lead bank. And secondly, at 23, it's important here to note the appeal of the syndication was also a significant part of the prospect of further working capital funding. The BBH needed working capital in order to maintain its businesses and grow. I did not simply want to give the banks additional security on their existing loans and get nothing in return. So that's from the very beginning. That is consistent with the document. If your lordship turns to page 146 of the bundle, which is in, I think, bundle B, put that to one side for now. You will see at page 146 to 7 is a 3rd of May email. That's at the bottom of page 146 and goes over to 147 from Mr. Vig to Nor Bank officials, Mr. Khan and Mr. Natfi. And the Lordship will read that to yourself. You'll see it begins further to discussions. So they've already talked about what he's now setting forward. I've shared a detailed information memorandum. Lordship, read that yourself rather than having it reached out for you. That's the first two whole paragraphs.
Yes.
And so you'll see that from the very beginning, consistent with the chairman's witness statement, they are seeking a a club deal for 2 billion, including a working capital facilities of 300 million for Durham. And that's a figure we keep seeing all the way through as a figure that they've needed. You'll see this much later on in the year. Going forward at page 156, and this is a point just of note, it's not central working capital, but you will see this is a report of what the existing lending was as of that time, before Norbank had got in to lend some more money. And in there, of the existing lenders of 1.9 billion, you will see Norbank has only in there for 15 million dirham. So it was a relatively small lender at the time. And this business was an opportunity to increase its business substantially. So you can see the commercial reasons why Norbank wants to take part in this exercise. Going forward to 177, you'll see on the 3rd of June, going forward, an email from Mr. Khan of Nor specifically asking what our requirements were about working capital. The Lordship would just read that. It's headed, Dear Misbah, can you please advise what would be the requirements? Does your Lordship have that? Page 177.
Yes.
They knew it was important. Please advise so we can get it incorporated into the credit application. What do you want? What do you want? What do you want? This is trying to get the business in. So it's absolutely essential. They know that. Going back to the witness statement of Mr. the chairman at paragraphs 26 to 7, back on 1318. I could probably read this out if you're finding it difficult to get straight to that.
I've got a printed off copy. So
okay. Well, if it's not too difficult for you, then then it's probably worth you turning up to 26.
Yeah.
Which is that the Norbank came up and were attractive and supportive, and they were confident to be able to put forward the money. Reads 26 and 27 to yourself, my lord.
Yes.
All positive about them and the working capital. Now, in the Norbank's own internal documents, you'll see this reflected back in the B bundle at page 181. This is a credit application for the bridge facility. Your Lordship would have picked up that Norbank during the course of the summer granted a bridge facility, which then they attached a syndicated loan issue later on in the year. And in granting the facility, they're saying, how is it going to be paid off, this facility? How is it going to be, what's the exit? And if you see under option 1, or rather halfway down page 181, the takeout of the bridge facility. So this document you'll see from top right is the 28th of June 2018. And option 1, how are we going to take out the 500 million facility? Option number 1, syndicated facility. Option 1, syndicated term facility. Syndicated, and Lordship read that, but you'll see there the reference at that stage that they're going to be taken out by the 2.2 billion syndicated loan, of which 1.7 will be reprofiled existing term facilities, and the remainder, that is 300 million, should be working capital facilities. So that was still, that's within Norbank. It's interesting at this stage, your Lordship, to note at 185, as is normal, you have a list of the relationship officers, or rather, you have the relations of, and then you can see the credit officers who were going to be receiving this at page 185. Kazim Ali is the head of corporate banking. He's likely to make the witness statement, and then you see the names of the various credit officers who are going to have to consider that. Nothing unusual there, but I want to say that you also can see some of the names. At page 233, going forward, and this is the 15th of July. This is a letter from the Nor Bank explaining the approval of the bridging loan, and again, it explains how the exit is going to be from a syndicated loan of 2 billion. This is at the bottom of 234. Option 1, syndicated facility. So it's the same phrase. Take out the bridge facility, one of the options. Syndicated facility up to 2 billion for reprofiling of existing debt, involving 3 billion of working capital facilities. So that's still anticipated. And that's only on the 15th of July. At paragraph 19 of Mr. Kazi Ali's own witness statement, which is in the B bundle just behind there, you'll see that at this stage he's practically admitted that the 2 billion has been promised. He certainly says we're very positive. It's paragraph 19, and it is at page 119 of the B bundle. We say that they'd assured that we would give the 2 billion. He more or less admits, he says, I think it would be fair to say they're optimistic that substantial syndicated facilities. So that's the story up until the beginning of August. Throughout this period, several months, not only working capital is not only important to us, but seemingly understood by all, including Nor, that it would be part of the syndicated loan. We then get on to the next period, where things seem to change, but there seemed to be some indication of, as I say, side promises. My learned friend pooh-poohed that this morning. But if I take your lordship in detail, you may see there's more to it than we think that would benefit from disclosure or and cross-examination of witnesses. So the second period, 1st of August to the OBN meeting in mid-December. Now, first of all, it is plain and accepted that in the course of providing the bridging loan, Nor Bank demands to be made the lead arranger for the whole 2 billion syndication. Or my learned friend took you to that document. We then see the document at page 260 of bundle B. Now, in that document, you'll see immediately that the sum included there is just 1.75 billion, and it has been reduced now from the 2 billion. It doesn't include a working capital element. Now, just stepping back, it's odd, surely, to see this reduction from Nor to a key demand of the group up until that point. The key demand was for working capital, especially when Nor's own document says it's likely the 2 billion loan was on the track. Now, including working capital, but only 10 days before. Now, Mr. Ali's explanation of paragraph 25 of his witness statement bears looking. Which your lordship will find at page 121. The IMLA set out the terms in which the Nor Bank was appointed, so forth and so on. Middle of the sentence. There was no mention of working capital in the IMLA letter. Although the BBH Group's initial proposal being for a 2 billion facility to refinance existing lending and provide working capital, it had been discussed in the BBH Group that the syndicated facility would only refinance the existing debt, and that the BBH Group would have to approach its existing lenders or other banks to arrange working capital facilities. So they're saying nothing to do with us from this stage. Cut and dried is his basic premise, but he's very vague about this substantial change. There's no just simply it had been discussed. No details of who on either side. And it seems just vague. Is he referring here to when he says Pjsc would have to purchase his existing loans to other banks to arrange working other banks? Is he suggesting, well, it's not going to be in the term, but it was made clear that it might be part of bilateral agreements, that we might provide that. We're not told. It can't exclude it, because if North Bank suddenly turned around and said there's going to be no working capital, given how important it was, they'd obviously might lose the business. Your Lordship might say, well, you're building quite a lot out of little here, but given the importance of working capital, we would say not. And your Lordship will see a bit more in the September documents what I'm getting at. And so we would like to cross-examine Mr. Ali about this change in paragraph shown by the IMLA agreement, and to have some disclosure from NOR about from internal and external documents about what was the rationale for reduction, how they envisaged working capital was going to be coming to us. Of course, your Lordship should note that as part of IMLA, part of the IMLA agreement, page 260, there is a clause. I don't know if I can take you to, as far as I recall, it'd be great to be did. At clause 5.1, during the period from the clear market clause, your Lordship will want to read that to yourself.
Yes, I highlighted that.
You highlighted that. So we can't go to anyone else during this period to get money, basically, without their permission. So except presumably NOR. So it looks as though it's being steered to them, but it's not explicit in this term agreement, the working capital facilities. So maybe it's on the side. So we've no way ourselves of knowing if side promises were made in this respect, because none of our actors are cooperating with us. We have no material amount of documentation. So we say we need material from NOR and disclosure about this. And your Lordship's seen other clauses of that. I'll come back to other clauses later in due course. Can I ask your Lordship then to go forward to 487, which is quite a lot in the bundle, but not much in time, goes to the 2nd of September. So there's no evidence of any pushback, I'm sorry, I should say, from the group about the reduction of the facility and the exclusion of working capital. So again, we think is resolved. There's no comeback at that point. Now, if it has already been allegedly decided we wouldn't get it, 487, a few weeks, maybe a month later, Mr. Ejaz asks, that's Misbah Ejaz, pleasure meeting you and the team. This is Mr. Mirza of Norback. You and Mr. the team last week. As agreed, we're waiting final term sheet from your end. Please share it today. And he's discussed meeting HSBC. At 489 and 492, Mr. Mirza Ali sends back to him in the middle of 489 the attached draft timesheet. Please, reference to our ongoing discussions, please find the attached draft timesheet for your review and feedback. We kept broad terms aligned with the term sheet shared by the company and agreed with banks. And that term sheet, your Lordship will have further on in the bundle at 492, reflects the IMLA letter, and it has a facility amount at 493 of up to 1.75 million. Mr. Ejaz's reaction to this letter, we say, is key and instructive. And it's copied to everyone. And if we see that at page 503, so Mr. Ejaz's original email was sent to Mirza Ali and Adnan Khan and copied to a range of people. And Mr. Ejaz at page 503 in the middle says, please find enclosed amended term sheet. As discussed in our meeting, in addition to 300 billion working capital lines, and so they've already discussed this on the side, we are requiring 200 million bank guarantee limits, current exposure of bank guarantees. I would suggest to include working capital guarantees part of syndication deal. because in case these limits will be arranged on bilateral basis, then assignment of already assigned contracts against working capital limits, and as well for the new contracts, will reduce the collections for the syndicate banks, and operation bring a challenge for us as well for the syndicate banks to ensure what level of collections are being taken out. No truer word said. So he further, I would endorse your suggestion that participation working capital lines from banks should be important to their respective exposure in the term loan facility. And you can see, your lordship, the page 508, the term loan sheet he sends back. And you'll see that under facility, you've now got 3 facilities, 300 million of working capital. They talk 200 million of bank guarantee limits and the 1.7 billion syndicated term finances. And so this letter completely undermines Mr. Ali's witness evidence of paragraph 25, and he said it has all been discussed, they weren't going to get this. It is instead saying, this is what we expect, and we've discussed it. And even more, he says, that if your lordship, I would endorse your suggestion that participation in working capital lines from banks, this is coming from from Mirza, should be important to their respective exposure. And as the exposure of Norbank was going to be, I think, in the realm of 500 million, that is 25% of the 300 million or so. So it's a substantial sum of money that Norbank, Mr. Misbah understood. So it's not the email we see here and the term sheet, it's not the reaction of someone who already knows that BBIH's facility is going to be 1.7 billion without working capital. The revisions suggest it was still very much in his and the group's mind that Nor was going to arrange working capital, whether as part of the syndicate or in fact in part of the syndicate. So we say, by itself, it undermines Mr. Ali's witness statement, paragraph 25. It's credible evidence that the group understood that working capital was coming, in part from Noor as part of the syndicate loan, or somehow, although he was trying to put it into syndicate loan, consistent with the, we say, with the position so far. Now, Mr. Khan's reaction at page 520 is instructive. He responds a few days later. Hi, Misbah, the discussion we've had for 1.7 billion syndicate, mainly for term exposure, while understanding that working capital will be continued by existing banks or arranged by you on a bilateral basis, which is a sort of, on the face of it, looks like a flat, it refers to the stop line about coming from somewhere else. On the face of it, looks like a rejection, but the honesty is that Mr. Misbah at 524, the lordship has seen, goes on very quickly, goes, yes, noted, let's close the term exposure. So what's happening here? And it seems to us, this must be a reasonable possibility that what Adnan Khan is doing is saying, look, we have a 1.75 million, that's got to be the term. But you know and I know that there will be collateral working capital facilities arranged by us on the side will be involved in that. And therefore, that is what is meant by working capital as we continue by existing banks arranged by you on a bilateral basis. There's something else going on that is out there that either Misbah doesn't want it in this email, or simply these are promises to keep the thing going on. I don't know. We can't tell. We think this is classic for internal disclosure within Noor.
What would be the rationale for that, Mr. Fraser? It's tolerably plain, isn't it? They're having difficulty getting the support they want to get for the full sum of money, which is an obvious reason for reducing it. We know in the end they can't even get the 1.75 quite. They get 1.749 or something.
Yeah.
So that it's obvious that there's good reason for reducing the sums in question, simply because they can't get support. And indeed, we saw it earlier. They were looking to contribute themselves only 250, but finish up with a 500 in the hope of reducing it to 250. So the real question is, well, what's the rationale for something secretive going on here, as opposed to spelling it out?
because they don't want to lose the business. And therefore, if they were to absolutely say no, there is no working capital, given working capital is so important to the chairman and the group, then you can see the possibility that the chairman of the group looking elsewhere, having another lead arranger, doing something else that does not involve Nubank. So the rationale on the one side saying this is what it's got to be on paper, but on the other side of the blanket, as it were, making soothing oral noises about yes, of course, we'll arrange that on the side. There'll be a bilateral working capital facility. Don't worry, we'll get to there. Is I think a realistic possibility. I can't say it's a probability at this stage, but I don't think your lordship can discount it, particularly if we go on further into the bundle. You'll see another example of this.
Why wouldn't you have that? I mean, we know what happens in the end, where there's a side letters that are never quite finalized.
Exactly, yes.
But wouldn't you expect exactly that to be the position here if there was an offer of a certain amount of working capital on the side?
What I'm trying to establish is the evidence, I think, shows the possibility that things were being said on the sides to the group by Nubank officials, soothing noises about working capital. They may or may not have any intention of living up to them. We're looking at their internal documents. As your lordship says, it doesn't look particularly that positive that they were going to supply the working capital. But what keeps coming back from the NUR group, from the group, the chairman's group, are emails predicated on the basis that there have been discussions about working capital. That's still an issue. Now, your lordship may say, well, as a matter of commercial rationale, I can see why they'd all dropped. That's possible. It looked at objectively with hindsight, but at the time, Nubank wanted to keep the business going on, and the chairman's group wanted working capital. It's very clear. There's no doubt about that. I don't think it's so commercially impossible for your lordship to go, I can't see that. You can see that it could be happening, and the way these emails go on, and the subject doesn't disappear from the chairman's side, does, to us at least, indicate that there's something to be explored here in disclosure and at trial. Now, of course, Mr. Ali is very keen to say, because he's very cut and dried and wants the whole subject, for example, not even to have been raised at the December meeting. His own evidence is at paragraph 33. Page 122 of the bundle, about this exchange. It was made clear to the BBH group, as was set out in the letter, that any syndicate would only provide a term facility of 1.75 to refinance the group's existing borrowing. If the BBH group wanted working capital facilities over and above that loan, then it needs to go into the market to obtain those facilities separately. And our point is that doesn't seem to, that's already in doubt, we would say here. Given Mr. Misba's reaction to the term sheet, it's not the reaction of someone who understands they've got to go into the market. On the contrary, it's the reaction of someone who thinks they're getting it from Nubank on one interpretation. We then see the term sheets as signed in the middle of September. Your lordship's seen those there at 548 and 585. Without any working capital. It's a term finance. Now, at 30th September, we then see these emails, which I would suggest these raise the reasonable possibility that there is side promises going on already, and they start at page 600 of the bundle. And as discussed, this is from Adnan Khan. I have attached the consolidated and individual cash flow projections that are to be used for the syndicate financing. This is the 30th of September. That's coming from this. These are internal NOR documents, and they, as Mr. Ali accepts, are predicated. They're 603 onwards, predicated on working capital being provided separately, not necessarily by Nubank, but there's provision for the financing of working capital loans on the side. At 628, Mr. Ejaz, in response to that, says in the middle, gets the email, "Dear Adnan, kindly also update us regarding working capital facility mechanism. It's a must, otherwise the whole syndication effort will go useless." And we say that it is plain from that, or arguable from that, that the group still understood that working capital would be coming or would be arranged by Noor, even if separately. And we say it's real evidence that working capital is central to the syndication. It's a must, otherwise the whole syndication will go useless. And also that Misbah and the group must have been told by Noor that they will, or arguably told that they will arrange the working capital, and it's not in the documents. So we don't see that anywhere in the documents. So something is going on that we've been told. We would say this is evidence of that, of promises, discussions of working capital on the side, whether it's arranging it or supplying it or something. Now, and that is, if you like, is completely at odds with Mr. Ali's witness statement that I took the lordship to, paragraph 33, when he said several weeks before it was absolutely off the table. It couldn't be clearer, black and white. It's not black and white. It gets even stronger. You see Mr. Khan's response. It's not, don't know what you're talking about. We dealt with that weeks ago. Haven't you read Mr. Ali's witness statement? He says, let's have that sorted tomorrow. The implication is it's acknowledged that Noor Bank would sort it out, as they seem arguably to have promised the group. Now, we say the presumption must be that Noor Bank did provide further comfort in this regard for two reasons. One, the syndicated loan process continued. And as we know from Mr. Ejaz's, working capital was a must, otherwise the syndication would have been useless. So he had to have been satisfied, or his superiors had to be satisfied, or whatever Noor Bank sorted was sufficient to give them comfort to go forward. So something was happening. And then at 631 is this email from Mr. Khan a couple of days later, presumably following that conversation, whatever is going to be sorted between them, following that interaction, he sends back, and I accept that it must have been coming back, because it says, "I hope this finds you well. We were earlier provided with 2 attached files. We accept that must come from them. But they have been circulated internally within Noor," and showing the borrowing exposure of AFM Group Syndicate Group. And going over the page, there's at 633 and 634. Don't forget that within that future banking partners exposure, that letter, beginning of October, is a column at 634 of working capital, adding up to 300 million, of which one of the participants is Noor Bank for 100 million. So the numbers are there. They're consistent with back in the summer, and they're going to be consistent with what the chairman then in due course says in his witness statement. But so there's the 100 million figure. Now, he sent back these documents and asked for further material on it. We have more detail. We need internally to assess position, and he doesn't, in sending these documents back, he doesn't say, "What are you talking about? Don't be ridiculous. We're not participating 100 million of working capital," does he? It's there, and he's saying, "We'll say more about that," and so forth and so on. So again, we say it's a crucial exchange, and it indicates a side channels of conversation, and it makes complete nonsense of Mr. Ali's witness statement, paragraph 35, saying that working capital has nothing to do with Noor. It makes Mr. Ali, we say, on the face of it, an unreliable witness of fact, and that is going to be important when we come to consider the 16th of December meeting evidence. Now, his Mr. Ali's attempts to downplay this exchange, we say, are pretty weak. We can pick those up back in the bundle. He addresses it at addresses it at
39.
39, exactly that. Yes, there we go. He addressed it at 39. If your lordship reminds yourself, I do not now recall what was sorted on the next day, but there was certainly no agreement by Norbank to provide working capital, which is his narrative. But it's not convincing, and then he's praising aid to the keenness reduces the exposure, but it's not convincing when faced with the documents and the way I explained to your lordship, is it? We would submit. It's pretty weak. He doesn't have any recall of this. I doesn't know this, although he has recall of other matters. But this rather important matter, he simply says he doesn't know, and he wasn't a party to it ever. So this is. He tries to say it's certain that no agreement to provide working capital, but the emails do tell us another story, and we say there's no basis for certainty. And what the lordship doesn't have is a witness statement from Mr. Khan to corroborate Mr. Ali's witness statement, because he was the one involved. Does he corroborate that? No. So we say this is exactly the sort of area where full disclosure from the claimants and cross-examination trial would tell a judge much more what was going on in terms of what Nor was promising in terms of working capital along the syndicated loan facility during this period. We don't have the documents of the employees anymore. Nor's documents will be the best record. There's no evidence that they don't have any, unlike us. So what we can say for present purposes, they do raise an important prima facie case that Nor was promising to arrange or supply working capital outside of the syndicated loan, including as to 100 million from itself, which, as I've said, is consistent with what the chairman says was promised orally. And there's nothing in the documents that was being supplied after this email between now and the 16th of December, which tells us this scheme or this plan was withdrawn or rejected by Noor or made clear. It must proceed on the premise that in some form or other it was still extant as a possibility. So that's part of the background. Your lordship has already seen at page 643 and 647 these are commitments effectively from syndicate banks, both of which envisage working capital being provided for outside of the term loan as part of an overall scheme that was going to necessitate. There's no indication there that Norbank was going to be involved in that. It's simply they both make reference to example. It's not a strong point, but it is there. 643 and 647. Now, 651, which is my learned friend's 10th of December internal credit application, which he places a lot of store on. We accept there's no mention of side promises to us of working capital or working capital within the syndicate loan, and there is a mention of reduction to 250 million, and the seeking of the OBN storage facility security. We say the reduction was never this, and this is the first sign of it. We see it internally, but we've never been told it, as your lordship picked up this morning. There's no evidence that we were told that this was a long-standing desire of Norbank, whatever Norbank internally was talking about. And so, in terms of whether it's likely that we would have raised working capital, if there was this long-standing matter, we weren't aware of it. So it's not such a strong point that we would suggest. If we had been consistently told of it, you can see why it would be an important point. But it doesn't look like it was raised with us at all, this reduction concept. It does allow for working capital elsewhere. And it's consistent with a hypothesis. It's simply possible either the Nor credit team was not told of everything that its corporate banking team were up to or saying to get a deal across the line. Nothing totally incredible that's the case, or not being recorded or whatever. It surely won't be the first time that's happened, or it hasn't been committed to. Anyway, we don't have general disclosure of emails between the personnel, so it's all a bit to understand the backing of this credit application. So we're not sure how much this takes it forward for lordship. Now, the chairman's witness statement is instructive here, but he takes us on to the next part of the narrative, and that's at paragraphs 32 to 34. And this takes us to when it became clear, at least to the chairman, that the the syndication wasn't going according to plan, and he blames it on Norbank. In fact, he thinks they didn't do it particularly well, and he was having to think about, as Norbank hadn't committed the working capital, he's having to think about other ways to raise money on the side using this very important OBN security. So perhaps your lordship would read 31 and 32. I needed a plan to deal with bilateral loan. 32, 33. Effectively, he's saying, given how useless they were at raising the finance after much early promise, he was considering raising bilateral finance against the security. He wasn't, the group was in financial difficulties, he was putting money in. He didn't want to pledge OBN to Nur, as thought better off getting the money elsewhere. And then he is told at 34, then he's told that Norbank wanted the mortgage against OBN, was otherwise threatening to ruin the syndication. He said it was cross because where it got to, they were suddenly threatening to drop out without the security. It's important. It's not just a promise not to participate, but it's a demand for security to do so. And he's told he did not have the right to give Norbank security over OBN. So it was the only way, and if we provided a mortgage, this would allow us to obtain working capital from the syndicate. That is some evidence that this was being floated as part of the OBN deal already before the 16th. This is what he's been told by Mr. Beck. He says he's skeptical. He was worried about the relationship. He might be better off getting it elsewhere. So he comes back to have a conversation. Now, at 657, going back to the bundle email. You'll see this internal debate my learned friend relies on on the day of the meeting about evidencing the Nur's desire to get the sum down from 500, their exposure down from 500 to 250. So therefore, he says, well, the whole theme of their evidence is, well, we would hardly be promising more working capital, would we? The answer to that are numerous. I'll come to, but one of the obvious ones is, of course, if to get the exposure down, you have to make a promise, and you do make a promise. Well, we want to get the security. The key thing is to get, the security. So if you get security, which is going to be of significant value, greater value, you have to make a promise to do so. You can see them doing that. They're not completely inconsistent, but even the desire to reduce exposure along with making the promise to get the security, not completely consistent, we would submit. But what we do see here is it's not even a consistent position within Nur. It's not completely shared within the credit department, because we have the email from Mr. Butt within the credit department at 657. We have not only this email there, and he says, dear Umar, at the bottom, your lordship saw this earlier this morning. I'm not privy to what you communicated to the BECC. However, my email of the 24th of July, which is appended below, did not state the syndicate will reduce the exposure at close for reasons that I thought were clear. I also note there was no deadline after reduction, therefore none was given. Now, stopping it there, my learned friend said, oh, you only quoted that bit. You didn't quote the next bit, which is about the premise of an April sell-down date. But actually, if you go, the reasons he gives at the 24th of July in his email, the 24th of July, which is behind at page 661, is that he thought actually the credit was pretty good. And that he didn't see a need for the sort of closure date and the deadlines that were being raised in the summer. So he's referring to that. Your lordship might just read that yourself at 661. His email the 24th of July. It begins, Faisal asked me to respond. Point 1, we were not permitted to sound out banks. Does your lordship see that?
What do you rely on this for?
Sorry, what I was relying on is a division. It evidences the email of the 20th. Basically, Mr. Butt's email of the 16th of December at 6:57 cross-refers to his earlier email of the 24th of July. And that earlier email indicates that he, at least, thought that the credit was good. He's reasonably confident this will be a successful indication because the credit appears sound and so forth and so on. So there is division. My learned friends say, well, it was all about difference of closing dates. But actually, what Mr. Butt is saying, even in December, was that I didn't think that we were reducing our exposure because I thought that for those reasons I gave him the 24th of July, I thought the credit was good. So I think it's just evidence.
It's paragraph 3, isn't it, Mr. Fraser, you need to look at as well. It's the timeline for reducing the take.
Yes. And he says, I'm not doing so. I haven't been asked to do it, and I'm not doing so.
And he's happy that he thinks they can get the 1.7 billion and the cash flow is good enough for repayment on that, as long as it remains at 267 million.
Yeah. But what it's not consistent with this narrative of constant pressure to reduce the profile. Therefore, no one would have made a working capital promise.
Right. Okay.
That's what I get out of it. And so that's where we get to, leading up to the meeting. Now we then go into the meeting, and which is the third set of evidence. We say the overall evidence plainly gives a real prospect of showing the disputed oral statement, the working capital statement made at the meeting. So the 16th of December meeting it happened between Noor and the chairman, and it's agreed by all parties to have happened. So our case is supported in that respect. It's agreed by all parties that are attended by the chair, and his evidence is he hadn't attended another meeting with Noor. So an important meeting at which significant promises may have been made. It's agreed by all parties that the subject of OBN as security for Noor was raised. That's accepted. And it's also agreed that Noor threatened to pull the whole deal down if the security not provided. Your Lordship can see that in Mr. Ali's witness statement, paragraphs 49 to 50. No, it's not 49 to 50.
63 onwards.
Yes, it's 63 onwards. We made it clear without the security the syndication was likely to go ahead. So that backs up our evidence on that. And indeed, that's half our case made on economic intimidation, because that's the withdrawal threat. It makes our case on that aspect. But while they admit that, the withdrawal statement, the question is whether the carrot part of our case, the working capital statement, also happened. Now, the prior evidence I've gone through up until this moment, my lord, we say is supportive. Clearly, working capital is important to us. Norbank knew that on the evidence before your lordship. The OBN is important to us. Not going to the chairman's evidence, not going to promise it away unless it gets something more in return than just Noor participation. Needed working capital to make the whole syndicated loan work. You've seen that throughout these documents in the chairman's witness statement. Your lordship has seen some evidence, we'd suggest, that Noor may have had a habit during the syndication process of making oral side promises to us concerning working capital, not all of which may have been reported there internally within Noor to their credit colleagues. We don't know, we can't see them. They certainly aren't reflected. So there's some evidence of that. Then, with that background, look at, I ask you to read the chairman's own evidence. It's pretty compelling on the subject, beginning at paragraphs 35 to 37. 35 to 36, and it doesn't go beyond. It doesn't overclaim. He says, I can remember some of them. I do recall that both Mr. Khan and Ali were there. He says he sets up Mr. Ali's claims. And then at 40 to going on, I'm going to come back to the Salam Bank issue in a bit at 37 to 38, 37 to 39. He again gives fairly compelling evidence about 40 about that working capital. He says it's untrue that working capital was not discussed. The discussion was solely about their exposure. That's what it said. The two topics linked to one another. It's true that Norbank stated they want to reduce their exposure. That's what we say.
Is that meant to read the discussion was not solely about Norbank's exposure?
Well, I think. Well, I've read it as I think that must be how it must be taken to be read. I'm pretty sure, given the contents of the rest of the paragraph, because it's also we go on to talk about working capital.
Well, it's the two topics linked into each other.
Yes.
Which I think what he means is that there was a discussion of working capital and not just about reduction of Norbank's exposure, because he then said it's true they wanted to reduce and said they didn't want to proceed, etc.
Your lordship's laser eye has spotted that, with others clearly not. I think that must be right.
It's always a bit serious if one adds a not in the middle of an important sentence. So I don't want to make that assumption at all.
No, but I think that's correct. I will check that, but I'm pretty sure that is supposed to say. Then he says they want to reduce their security, but he needed OBN, and the BBH group needed fresh working capital that was going to succeed and grow. We've seen that as a constant part of the discussions, that something had to be done in terms of, and that's why he needed OBN. They then say, why look to others? You could look to ourselves. Norbank's representative explains to me as follows. Now, my learned friend makes a point. Well, he can't ascribe one sentence to one of them. He's not trying to be absolutely precise. He's giving a sense of what he was told. And I might add that Mr. Ali's witness statement does the same thing when he talks about statements were made by Norbank. He doesn't say I said this or I said that. Is that Norbank said this and the chair said what was coming back. So there's a common approach to this, which is to say these are the statements that have been made. Even if we can't say precisely who made the statements, that's the evidence. Mr. Chairman is no less reliable in that respect than Mr. Ali. He then, they set forward why Norbank, why would we go to someone else? Norbank's going to need us. Why would the banks not give us working capital? They're going to get it from them. And then there's the specifics about a haggle over 350 to 450. They would try for 450. Thought the other banks would support this. Crucially, they said even if the full 450 was not arranged, we're on to 43. They guaranteed to provide $1 million, 100 million in working capital by March 2019 at the latest. Now, at some point, it's say, well, that's too imprecise to be something to be certain or enforceable. But a minimum 100 million means 100 million. That would satisfy it. By March 2019 gives you a date. And he goes on to say it's not something they would really consider or try to do, like the overall working capital, something they would do. It certainly has the ring of truth. And given what your lordship sees as the background, I don't think your lordship could really regard it as implausible, given the background that these promises were made in this way. And he says, I just would not have been satisfied with mortgaging OBN on a promise to consider something could just fall through. He needed their funds, and otherwise he'd need OBN to raise funds from the bank that could. 44, I think he makes a statement here that, oh, well, he responds to Ali saying, well, we wouldn't have had authority. He's saying, I assume that they've come into this important matter, they've come armed with authority to do a deal that they can commit to. Mr. Chairman himself was a senior, well-known banking figure who attended to high-level matters of Jacob Power, that sort of thing. And he would assume that they had the authority to give the deal. And you know that he must assume this, and so I'm going to come on to, my lord, because 9 days later, they give them the security on the faith of this promise. 9 days. Without this side agreement was supposed to have been drafted, in good faith, my clients arranged for the OBN security to be executed on the 25th of December. And your lordship knows the authorities about performance, part performance is by one party is much more likely to make an unexecuted agreement required to be binding, and that's what happened on the strength of this, and it also adds credibility to the fact that these promises were made, and even they believed they had authority because he went ahead and did it, and I think that's a pretty strong point on that. And so he thought that they had the ability to do this. At 45, he makes, I think, an important point. He's talking about this reduction in exposure point. He says, as I understood it from North Bank representatives, their concern rose from the amount of security that they held. They wanted to ensure that any exposure they had to the group was properly secured. And so at the moment they had mujmat, but they would have to have handed over as part of the syndication, and their exposure would have been too high for lack of security. Hence the desire to sell down the exposure. But if more security could be provided, hence the OBN, this notionally would increase the level at which they could lend to the BBH group. And you also can see that commercially. So it doesn't make, not completely strange, the thought that they might make a promise to that effect, if they could, as a result, get this valuable security to reduce their exposure. That's his thinking. He sets forth the rest at 45. 46, the written agreement points, common make deals over a handshake. He would then expect it to be recorded in writing. 47, I think that as partly the nub of this, he says he was in a difficult position. The BBIH group was under extreme financial pressure. I needed to do what it took to ensure it would survive. The syndication needed to go forward, but Norbank was threatening to derail things completely if they're not given OBN. Further, they were promising to provide the working capital. I had no choice but to accept their terms and agree to provide them a mortgage over OBN. He thought he was giving them the mortgage and their capacity as lead bank, and this is important because he thinks that's going into the pot for the banks.
How would you have thought that?
At the meeting, that was his understanding. I was giving them all their capacity as lead bank and syndication. As set out below, it's subsequently emerged they didn't share it with the other banks, and your lordship sees that at 54.
Yeah, well, that's
whether your lordship
thought
it was reasonable for him to think it. I think it's clear as evidence that he did think it.
Well, I find that that just seems to be inconsistent with what he says earlier. You know, what he says earlier is that they want the security. They want the security for themselves in place of Mumat, which is going to the syndicate. So I'm not quite sure how he could have thought what he said.
I see exactly what your lordship's going towards. But all I say is the evidence is that in some way he felt that this was a security that would be given to Norbank connects to the syndication facilities, and how that. And he did seem to think this because at 54 he talks about he brings up the question of OBN in front of the other banks, and it's strange that something strange has happened. They didn't appear to know about it.
Yes, they're not very pleased.
They're not very pleased, which you could probably understand. But so that's his evidence on that subject. So then that's the position with his statement, and he says it must be, we'd say it is all believable and certainly plausible. It's a statement of truth. He's a respectable businessman of previous good character. No grounds to disbelieve him otherwise, we say, my lord. It's a strong witness statement. Your lordship cannot ignore. He might be right, we think. The trial judge may consider he is right. It's not enough, we think, here for your lordship to safely conclude that he is not telling the truth, given the background of votes I've taken to your lordship. Now, looking at Mr. Ali's witness statement, paragraph 60 to 67, where he disputes the account, we say he doesn't remotely dispel its plausibility so as to render it incredible. Indeed, if anything, Mr. Ali's evidence looks slightly incredible. And so, if I ask your lordship to pick up Mr. Ali's witness statement of paragraph 60.
Can I just ask you a question about the mortgage, Mr. Fraser? I'm not sure I've actually been taken to the mortgage and as to whether it helps at all as to what it was provided for.
It may be a question I might need to answer overnight, but
yes, okay.
can I report
my
the question?
recollection is that I've seen a document which refers to the mortgage and what it's for, but I haven't seen the mortgage itself. But I'd be quite interested in seeing the exchanges in relation to the mortgage and the mortgage document itself, in case it assists. It may be so vague in terms as to what it covers that it matters not at all. But
yes, I've seen that. I think I've seen the same document, Your Lordship, which is the 25th of December record of the mortgage. But Your Lordship wants to see any documents surrounding that, and I will raise that as a query if I may. Okay, so Mr. Ali at page 127 of B. At the meeting, he addresses from 60 through to 67, and at 64, he says there was never any discussion about working capital. As far as I was aware, they were in discussion with other lenders, and other attendees said anything about North Bank, and we say that surely there are grounds to disbelieve that statement in light of the course of the negotiations in 2018. What was being demanded and what was being demanded by Nor at the meeting. OBN was being demanded, and that was critical to the group getting working capital elsewhere. On the face of it, it is extremely unlikely that it wasn't raised at all. And that, we say, it makes Mr. Ali's whole evidence slightly suspect on this, about this meeting. Your Lordship has already seen that Your Lordship has reasons to doubt some of his earlier evidence, and put it no stronger than that. Paragraphs 25 and 33 about working capital and no longer being an issue between them from the time of the Imler letter, which was the beginning of August, and then again early September. Whereas we've seen later emails showing it very much was up in the air. So Your Lordship has grounds to doubt some of Mr. Ali's witness statement earlier, and we say this statement, there was never any discussion on it, just seems incredible, or certainly grounds for disbelieving it. He says it was just a straightforward meeting to get security over OBN security. But if that was the case, then was there really any need for the chairman to be there? Because they made the demand and they were simply obtaining it. Would it come through? What's the quid pro? What was covered? There must have been a quid pro quo being discussed. Seems extremely unlikely to Lordship that could have been. And then he says there's a question about, he said at paragraph 62, I recall that he mentioned he may be able to get Al Salam Bank in Bahrain to commit to them because his brother, Khalifa Bouti bin Omar, which I think Your Lordship is aware of, was at the time the chairman of the bank, but this seemed to us very uncertain. And the chairman's evidence takes tremendous exception to this, and I think it's worth reminding yourself, Your Lordship, of his evidence about that, given the implications of raising that name in front of Your Lordship, which is...
I'm not a jury, Mr. Fraser. There's no guilt by association.
I'm glad to hear that. My client will be glad to hear that. Paragraph 37 of Mr. Ali's witness statement, which is page 1321 of bundle B. Sorry, this is not Mr. Ali's. This is the chairman's witness statement in response to those allegations. If Your Lordship would read that, and I'm going to take you to an email.
Yeah, well, I'm quite prepared to accept what he says in his witness statement in the absence of any challenge. It didn't seem to me the email actually supported it particularly well. But basically what he's saying is he had a row with his brother.
Yeah.
And that was that. He wasn't going to have anything further to do. But there's also an issue, isn't there? Because he lost all the NMCC contracts as a result, which didn't help the companies at all.
Right. Well, there would go further material in that respect. But the point being here is that there is, because of the antithesis between him and his brother, it's literally even more unlikely that he would have raised that subject at the meeting.
Understand.
And the argument is that it's only been put there. This is an argument. I'm not saying that but this is an argument. It's put there because this matter was coming on for Your Lordship, and it's, as it were, guilt by association. Now, that may or may not be correct, but it upsets my client, the chairman, and we'd ask Your Lordship to read paragraph 39. He says he's very unhappy about that. But You understand that. So it's and there's paragraph 86 of our skeleton does set out some other points about Mr. Ali's evidence. I think your lordship has a hard copy of that, so if I just gave you the paragraph number. Matters of there's some vagueness and incompleteness. Points at
86.
Yeah, 86, 1, 2, and 3. It's more. These are more points about you. So he doesn't appear there to help the court, or where he potentially could help the court. There's a lot of vague stuff given without backup, and it just wants to be a bit cagey about his evidence in respect, even beyond the matters that I've already taken to your lordship. And of course, the important thing is that there is no backup of Mr. Ali's evidence about, it's the point we make in paragraph 87, about the meeting from other attendees from North Bank's behalf. So there is a clash. There are grounds to have doubts about Mr. Ali's evidence, but there's no backing evidence from Mr. Khan. Mr. Khan, who was involved in these events, or Mr. Naqvi and Mr. Sheikh, who attended the actual meeting. So it's a classic clash of evidence that needs to be resolved by cross-examination, we say. And also, we say it needs to be resolved by disclosure, because we need more material from within North Bank of what happened at the meeting. May have been reported back or otherwise discussed. We haven't got any, we think, sufficient emails about that. We need the full compulsion of disclosure to that respect before we can just accept at face value some of the limited material that's been put through. We'd want a proper solicitor-led search of the emails and phones of the attendees and so forth. Now, we do specifically address in our skeleton the points about the reduction facilities that Mr. Ali relies on. So we want to reduce our facilities, hence you can believe me. I've really made most of the points, but I just want to ask your lordship to read 90 to 95 of our skeleton in that respect. All of that just raises the spectre that that point made by Mr. Ali is not a clincher, put it that way. That's what we would say. Now, going forward to the last factual period, and that's, as it were, after the meeting, is the post-meeting evidence from, as it were, the 17th of December to the present. Now, what we'd say in summary to that, yes, we do accept there is limited documentary mention of the working capital promise, although we think we can see it refers to. This is not the killer evidence that my learned friend seeks to make of it. First, there is some post-facto documentary material support that a working capital statement was made, and I'll come on to that, particularly a January 14th email from Mr. Pjsc, and we think that the 24th of March, Mr. Vig email also tends to, on one view, tends to support that. And then secondly, and then there are the documented requests or evidence about further requests for working capital constantly made by the chairman through that year, which on one view could also support the fact that a promise was made which was not kept, and hence bringing it up, and eventually the chairman's evidence in that respect. And I'll take your lordship to that. Now, the current absence of more documentary or other evidence supporting the making of the working capital statement is partly explained by the chairman himself is not CC'd to many emails. There's not many coming out of him. We've lost the support. We don't have witness statement support for many of the key group people involved in the negotiations, Mr. Mustafa, Mr. Vig, Padia, and Misbah. So there's no access that we have to them. There's an absence of other internal documents, the reasons that were given in the chairman's witness statement, 17 to 19. And so far, there's limited, we say, disclosure from NOR. None, of course, from any other banks. So that could be remedied on disclosure. What does that take us overall? And I'm going to come on to the detail, but overall, what we say is the limited nature of the post facto documentary evidence and portal working capital statement wasn't render incredible the evidence I've already shown your lordship in favour of such a statement having been made at the meeting. So there still remains, we would say, a very real possibility of the defendant showing at trial and after disclosure and cross-examination that they will make out their case on this point. So let's look at in more detail, and that's the sort of nub of it. That's the overall look at it. Page 667 to 8. And this is an email to Mr. Vig on the following day. And is relied on by my learned friend. So they also might be there for me.
Yeah.
Yes, at the bottom of 667, from Mr. Khan, this is what we want. And this is the beginning. My learned friend tried a device this morning of separating out these early emails from what happens in January. I don't know if the authorship would have seen this, but he's saying, well, there's nothing in these early emails on the detail. And although there is this mentions this 100 million reduction in or increase in credits or decrease in reduction in January, there's no sort of connection. How can we see a connection? Actually, we could see a line straight from this email all the way to the 14th of January email that I'm going to show you. Because what these emails are about are the coming up with something on paper to record what was agreed. And there's a lot of emails about grasping their way to that process. And it's not finally done because Mr. Ali frankly admits they didn't feel they need to do it now. Why? Because they had the security. Because 9 days later, we gave them security in good faith, we say, on the reliance on the promise. And then they thought, well, you're not going to give what you promised, so to speak. The agreement never gets done. We've got our security. We're happy with that. So that's on one view what actually happened. And my learned friend is effectively praying in aid of their client, arguably welshing on the deal, and say, well, we never signed this. There was never any agreements, and we got the security. So we're sitting very pretty. But actually, the court should be holding them to their promise, really. And so we would ask you to look at it in that respect. So look, let's see how that pans out. Mr. Khan says, good morning, good morning, dear Mr. Rishi. As discussed in the meeting yesterday, we appreciate your support to have the following support. Creation of a mortgage lease assignment over OBN asset. Please show us the articles and ascertain who can sign and pledge of the shares. We need them very quickly. And we need them in the next few hours. And of course, this is an important point because in the rush, there is a rush going on. They want the whole thing done very quickly because the syndicate is closing. They want to have the security before the syndicate closes. And so everything has to be done very, very quickly. And that explains, in part, of course, one explanation, reasonable explanation for why there isn't a signed agreement in time for the security to be handed over, because everything's been rushed through. Don't worry, give us this now. We'll come up with a side agreement later. And they don't, actually. But it's a rush. And so in matters of rush, the niceties do sometimes get missed out. And it would appear that this respect, this arguably is what happens. So Dr. Rishi, so that's one. And it's important that the mortgage lease assignment and the pledging of the shares, we'd like in the next few hours. They don't want to, at this stage, mention the side deal. That's an argument. That might be why they haven't mentioned it. What Rishi wants to do is to close the syndicate loan. So he wants to get that done. So your lordship, what we don't know is what other emails are going on, but you can see the picture of speed that is moving on, and you can see that. Just pick it up at this stage of the document that I have got. Your lordship will have spotted earlier, which I think is the document I saw at 702. Is the mortgage registration certificate that just gives you the date over the ABN from the 25th of the 12th, 2018. If your lordship, does your lordship have that?
Yes.
And so that really was very, very quick. And as I said, I made the points about we did our side of the bargain, they should be held to their agreement. Now, although the formal agreement was envisaged with it, it wasn't done at the time, and it was never done by Noor or us. And the lordship can see that Mr. Ali's witness statement mentions this at paragraph 120, which is at. So what we're then going to follow is this attempt to come up with an agreement, which they then basically just let pursue, and it's 120, page 140 of the bundle. In the end, Norbank never sent out drafts or executed a formal written agreement in relation to ABN Energy or the Gulf of shares. This is because it had been agreed internally not to do so until Mr. Amro provided a valid pledge. He never did so and the bank never made arrangements. It did not need to do so because it already had the benefits of the mortgage, so had the security required. It was sitting pretty, even if we were not.
Where were you just reading from?
That was from Mr. Ali's witness statement, paragraph 120.
Yeah.
And of course, that's another indication that of informality of arrangements, that they didn't feel the need to execute a final agreement, but they are happy to have just take the mortgage as it were. The 28th of December, we have the closure of the syndicated loan deal, and there is evidence from my client's witness statement, paragraph 50, if I just refer to it, the Noor Bank was replaced as lead arranger by Nbd shortly after the close of the syndicated loan on the 28th of December. Now, they were said to be less flexible than Noor Bank. And then we have the exchange leading to the 14th of January email. We'll begin it, if I may, by going to page 695. So, six, 7 to 8, we've had the email to Mr. Rishi about the two demands, what they're going to want to have. And at 695, we have the email from Mr. Padia to Mr. Adnan and Akfi of the 19th of December saying, during our meeting with our group CEO and CFO, we have agreed on the following. One, to offer, so he's replicating what has come through to him from Mr. Khan. One, to offer mortgage on the OBN facility as an additional security to support Norbank existing loan exposure. Norbank will release the charge on the OBN facility if it is able to sell down its partial exposure by the 31st of March 2019. It's that dating there. They're then going to be, he talks about the Gulf of shares too, and they're then going to be share the draft side agreements in line with the above for our review. We will proceed with the above mortgage to enable the facility document sign off. So they're going to go on trust that this agreement is going to be agreed and done. Then that's 695 at 700. We're at, sorry, 697. We're asking for more drafts of the side agreements. Mr. Khan, that's at 697, sorry. At 10:41 on the 8th of September, nothing's come through by this stage. 10:41. We see Mr. Khan on the 8th of January Once I've done this exchange, I'll finish. Sorry, 1042. Mr. Khan to Mr. Mustafa, Mr. Vig, CC Mr. Padia. Following letters being issued today covering the Gulf of Pledged ABN security, which I think is effectively to reflect their agreement. Dear Sir, this is from the bank to the chairman. We refer to the following: the mortgage over part agreement gone by ABN. So that's still point 1, 2, the proposed pledge. Then underneath here, please note that we've agreed to release the mortgage as soon as reasonably practical after our exposure under the facility is reduced to 250 million and to release the pledge as soon as possible. That's 1041. And then what we then see at 1051 is Mr. Padia's response to that. So this is linked, the reduction is linked to the supply of the security. So these are the subject matters that are being discussed on the 16th of December. And on the at 1051, Mr. Padia responds, please find attached. So they've come up with their own version, if you like, the draft side letter on the ABN mortgage. Let us know if you have any comments. And what's the response? The attachment is at 1053. And what they're saying is this is what they want to put in it. We refer to the mortgage. And NOR agrees to irrevocably, unconditionally release the mortgage as soon as possible after NOR's exposure under the CT agreement funding has reduced to 350 million, not 250. So there isn't, as it were, increase in the credit being offered of 100 million under this facility. That it's not being reduced down to 250. It's going to stay at 350, and that's a significance. It's in the chain of emails about the agreement post the 16th of December, and we say that is good arguable evidence that NOR had promised on the 16th of October, on 16th of December, to make the 100 million available in working capital as a guarantee. The word effectively now filtered down to Mr. Pandia. Mr. Ali says he's wrong about this, but at paragraph 111, 112. But you would, at the very least, we'd say this needs to be explored at trial. And it raises a case that was indeed what was discussed on the 16th of December. And as I say, they had their securities, they didn't subsequently make the agreement. My lord, we've gone a little bit past 2 o'clock, but I hope that was helpful. And I'll resume again tomorrow.
Very good. All right. Same time tomorrow then, please.
Thank you.
Thank you very much.
Thank you.